Good morning, Your Honor.
Morning, sir.
Warren Brown, Deputy Chief Public Defender. Your Honor, we likewise do not believe that any conflict exists in this honorable court hearing these matters. If a conflict were to arise, we would waive such conflict so that this honorable court could hear these matters.
Never been so honorable. Anyway, the court for its part also does not believe there's conflict either under the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people versus Valerie Johnson.
Yeah. Assistant Public Defender Hannah Apple hearing on behalf of Ms. Johnson.
Johnson, can you state your name?
Since I don't see her.
Okay, this is a good way to start.
No, she's not really.
She's not on.
On the docket, it said 10 a.m. I don't know. if That's what the facility.
Court does call the case of people versus Robert Greenshields.
Good morning, Roger Gill on behalf of Mr. Greenshield. Mr. Greenshield, would you state your name for the record?
Robert Cloud Greenshields.
Thank you, sir.
Judge, Mr. Greenshield's in, to my understanding, in Oswego County Jail. I need to have further contact with him. The prosecutors offered me a misdemeanor. Unfortunately, we can't do a Zoom breakout room, so I would ask if the court would give me a 3-week adjournment so I can speak with him.
I don't know if that was a request or whining, whichever it was.
It was probably whining.
He was whining. Okay, you do it very well.
Mr. Greenshields, are you still going to be in the jail in 3 weeks?
I have sentencing on October 9th.
So,
Okay, all right, thank you.
all right. Probable cause conference will be adjourned to September 25th, 2025, 9 a.m. Bond continue.
Thank you, Mr. Greenshields. I will get a hold of you, okay?
Yeah, okay, thank you, sir.
All right, thanks, Judge.
Thank you, sir. Court calls the case people versus Evan Sherbert.
Morning, Honor. Raymond Cook.
Sherbat.
Morning, Judge. Brian Bowling on behalf of Mr. Sherbert. Evan, can you state your name for the record, please? Your Honor, I'm asking for an adjournment. I did meet with Mr. Sherbert via Zoom yesterday at the Livingston County Jail, and we just need to complete discovery.
Probable cause conference September 25th, 2025, 9 a.m. Bond continue.
Your Honor, may I address one issue regarding bond?
Sure.
He currently has a personal bond on this case.
Got it.
With the court amended to a nominal cash bond.
Bond will be set in the amount of $1,000, 10%.
Thank you, Judge.
Court calls case of the people versus Stephanie Cleaver.
Good morning, Honor. Charlotte Stefan on behalf of Ms. Cleaver. Good morning.
Your name?
Stephanie Cleaver.
All right. What are we doing?
Your Honor, we are adjourning the PCC. I have discussed with Ms. Cleaver her right to the exam within 21 days. She wishes to waive that right. And the reason is for discovery, Your Honor. I just got appointed 2 days ago.
All right. 25th work for you?
Yes, it does, Judge.
Probable cause conference September 25th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Jeremy Anderson.
Morning, Your Honor. Raymond Cook.
Morning, Honor. Sam Bernstein with and on behalf of Mr. Anderson. Stand up for the court, Jeremy. Jeremy Anderson.
All right.
Your Honor, we are prepared to continue to exam.
Discovery is complete.
Yes, Your Honor.
All right. What date are we on? 16. People have their witnesses available the 16th.
Yes, Your Honor.
Preliminary examination in person, September 16th, 2025, 9 a.m. That is before Judge Washington.
All right.
Bond will continue.
Thank you, Your Honor.
Calls case of the people versus Frankie Hewling.
Remains up to the people, Your Honor. Good morning again, Sam Bernstein. It's not Healing.
Frankie Healing.
Thank you.
Asking for an adjournment for resolution, Your Honor.
Probable cause conference in this matter will be adjourned to old form. September 25th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Let's call the case People versus David Epps. I'm done with my outsides.
Good morning, Judge. Christopher Quinn appearing on behalf of Mr. Epps.
Morning. Your name? David Epps. Thank you.
Mr. Epps is requesting an examination, Judge.
Discovery is complete. Is discovery complete?
Yes, Judge.
People had their witnesses available to 16.
Yes, sir.
Preliminary examination in person, September 16th, 2025, 9 a.m. That is before Judge Perry.
Thank you, Judge.
Bond will continue. Thank you. Court calls the case of the People versus Donovan Friel.
Assistant Public Defender Jay Bellinger on behalf of Mr. Friel, who appears via Zoom. Mr. Friel, can you please state your name for the record?
Donovan Friel.
And Your Honor, we are seeking to adjourn this for possible media discovery on this matter. I'm not currently in receipt of any.
Mr. Friel has private attorney, Mr. Sam Bennett.
Oh, does he?
Do I have a substitute?
I don't have one.
This has got other counsel, but I have not signed the substitution.
And Your Honor, I was not aware of other counsel myself.
Who's the attorney?
It's Mr. Sam Bennett. He's in the room close to the chat.
Mr. Bennett,
Yes, good morning, Your Honor. Sorry about that.
are you representing Mr. Friel?
I am, Your Honor. Yes, we sent in a substitution yesterday. And Mr. Bellinger,
Was it signed off by the PDs?
it wasn't yet. We were just retained yesterday, so it was kind of a rush.
Where'd you send it? Because I don't have it.
We sent it to the public defender office waiting for a signature.
So the real answer to that is no, he's not representing him today. You're requesting an adjournment?
Yes, Your Honor. It sounds like Mr. Bennett would need that anyway, so.
Yes, that is correct, Your Honor.
September 25th, 2025, 9 a.m. Bond continues.
Your
Thank
Honor, Your Honor, given that I'm on the case or will be on the case shortly, could we do the following week, please, the 2nd, just to make sure that I don't have a conflict?
October 2nd.
October 2nd is not.
Thank you, Judge. And we'll get into that.
Hold on a second. Hold it. What?
Either Tuesday the 30th or October.
Oh. September 30th. That's a Tuesday, 2025 at 9 a.m.
That sounds good, Judge. Thank you.
Thank you.
And then, Your Honor, very briefly, Mr. Friel would like to travel to Indiana in the next.
Then he can tell his attorney in the case, and then I will consider his request.
Okay, thank you,
I
Judge.
need the substitution before you start talking on his case.
I understand, Your Honor.
Thank you. Court calls the case of the People versus Andrew Gendy. Pardon? Mr. Fanta?
Good morning, Your Honor. Andrew Fanta on behalf of, and with Mr. Gendy.
Your name, sir?
Your Honor, Ms. Douglas and I talked about this case, and she didn't know whether she would be able to fully discuss the parameters of the case before today's PCC meeting. Accordingly, I would ask for an adjournment to September 25th at 9 o'clock.
Well, I'll put it down. Any objection from the people? September 25th, 2025, 9 a.m.
Your Honor, if I may, Your Honor, if I could address an ancillary issue on the 29th of August, Mr. Gendy was arrested at home in the early hours of the morning for a violation concerning his tether. He had previously called 3 times, and his sister called once to the tether folks that there was something wrong with the tether. Accordingly, I would ask if you would release him from jail on a $5,000 personal recognizance bond until the 25th of September. I have personally known the family for over 25 years. Thank you, Your Honor.
That is not the information that we have. There were sirens and alerts going on. They were trying to contact him directly and were unable to get through to him. So I don't know where these contacts were coming from. And then they found the defendant was placed in custody. So certainly you would be entitled to a hearing on that, but I don't have anything other than that information. So if you'd like a hearing, you can certainly motion that up and I'll be more than happy to hear it, but I'm not going to change his bond at this time. Motion for bond reduction or change in bond is denied at this time. Thank you.
Thank you, Your Honor.
Court does call the case of the people versus, is it Centassia Callaway?
Then on behalf of the people, Your Honor.
Jacob, on behalf of Ms. Callaway, Judge, did you say your name?
Natasha Callaway.
Judge, I met with my client. She would like to pursue the matter through a preliminary exam. Judge, I'm wondering, I probably sound like I'm whining.
Discovery complete?
Yes, Judge. Is it possible we can make it out to September 30th?
Anything's possible.
Well, I know with you, Judge, it is.
Well,
I got a few more cases coming up. I'll be whining.
What'd you say?
Nothing. You're a great judge. That's what I said.
What did he say?
Judge, we have a big docket. We should move along.
People have their witnesses available the 30th.
We'll do our best, Your Honor.
All right. Preliminary exam. Will that date work for you, Mr. Kilwell?
That's the date I asked for. Thank you very much.
That was the date you asked for?
Yeah. Thank you for your very.
I don't know why I'm doing it. Preliminary examination in person, September 30th, 2025. That's, geez, Mr. Kilwell, we'll see each other again. That's a 12
Judge, you're very considerate
me.
this morning. You're very considerate this morning. Thank you. So
bond will continue. Does he have any more? Oh. Court calls the case, people versus Brent. Is it Hackbar?
Then on behalf of the people.
Morning, Your Honor. Dan Garrett on behalf of Mr. Hackbarth. He's stepping forward. You take your name to the judge.
Brent Hackbarth. Thank you.
Your Honor, we're asking for an exam. Discovery is complete.
People have their witnesses available the 16th.
We'll do our best, Your Honor.
Preliminary examination in person will be set September 16th, 2025, 9 a.m. before Judge Washington. Bond will continue.
Thank you, Your Honor.
Thank you.
Come up and see you, okay?
Court does call the case of the people versus Sean Edgar.
Edgar. Morning, Rob J. Kilwell on behalf of Mr. Edgar. Judge, I was just appointed late yesterday afternoon. I don't have any contact information because I was appointed so late. I would ask the court, respectfully ask the court to grant a 2-week adjournment.
All right. Well, he also has a violation. He's not reported to community corrections. So
I got that.
Issue bench warrants on both cases. Bond is setting him out at $25,000 cash surety. Those warrants will issue immediately.
When will they kick in? now?
As soon as they get to my clerks, they're going in.
Would the court consider maybe, no,
No.
I've used up
All
my,
right, thank you. Just trying to move it along, Mr. Pillowell. Court calls the case, People versus David Rasmussen. Just following your advice.
Good morning, Your Honor. J. Grant Miller, P58658, on behalf of Mr. Rasmussen, who approaches the podium.
Your name, sir?
David Rasmussen.
All right, what are we doing?
Your Honor, discovery in this case is complete except for the 911 calls. I've spoken with the prosecution. Those are already been ordered. We're asking the court to set this for an exam, please.
Your Honor, it should be involved before the exam.
All right. I'll mark that if they're not in, you would not be entitled to an adjournment based upon not having those. But people have their witnesses available the 16th.
We'll do our best, Your Honor.
Preliminary examination will be set September 16th, 2025, 9 a.m. That's before
Judge Perry.
Judge Perry.
Thank you, Your Honor.
Bond will continue.
Your Honor, may I address bond?
Briefly.
Your Honor, Mr. Rasmussen is a general contractor, self-employed. He's been in custody for some time now. We understand these charges are somewhat serious. However, reading through the discovery, I think that a personal recognizance bond with a no contact order would be appropriate in this matter. He's not to go to the address where the complainant is living, and he just wants to try and get back to work. This is his busiest time of the year with painting and getting people ready for the winter. And quite frankly, his 1987 pickup truck's in impound anyway. He's not a man of means, Your Honor. So $2,500 may as well be $250,000 to this man.
Respond.
Object any modification of bond. In this case, the defendant was angry at the victim because he thought she was sleeping with someone else. He then pushed her on the bed and strangled her with two hands. He later punched her in the face, and she had bruising around her eye. He also took her phone so she couldn't call 911. And when officers asked her about the strangulation incident, she said it's happened previously 4 times in the last month, and he always uses both hands and tries to make her pass out. So I have great concern for her safety. I would also ask for if he is released at some point. I was not sure if the tether was ordered. A GPS tether for address, so that also be ordered. But it's just how I reject any modification of bond.
It looks to me like it was ordered. Anything else, counsel?
Your Honor, I don't want to get into the merits of the case, but the same report also indicates that the victim was the first to be arrested till she changed her story and they decided to issue the warrant against my client. Additionally, she indicated she doesn't want to prosecute my client. So we can read the report or we can read the whole report, Your Honor. I don't believe he's a danger to the community at large. He has a very minimal record of one operating while impaired, I believe 7 years ago. I don't believe he's a danger to the community. He's a homeowner in Ann Arbor. He's lived here his whole life. He's 56 years old. He just had his birthday in jail over Labor Day. We're just trying to get him back out so he can work, because otherwise he's probably even going to lose his truck if he can't pay the impound fees on that. And again, we're talking about a 1987 pickup, Your Honor. We're not talking about a very wealthy man. He was willed the deed to the house from his mother, and he lives in his family home.
Well, at this time, based upon the information that's in front of me, I'm not going to change the bond. I wouldn't find that the magistrate setting a bond would be an abuse of discretion. So motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case People versus Isaac Sepulveda.
morning, Your Honor. Jake Hill on behalf of Mr. Sepulveda. What did you state your name?
Isaac Sepulveda.
Judge, I've met with this young man. He wants to proceed through a preliminary exam. Discovery's complete. I would, with some trepidation, ask the court if we could do it for September 30th again.
We want so bad to say no.
Well, you being the considerate, kind judge you are.
You know, September 30th Will people have their witnesses available? I guess I should ask.
We'll do our best, Joe.
All right. September 30th, 2025, 9 a.m. That is before Judge Washington.
Thanks. We'll talk.
Bond will continue.
Thank you, Judge.
Court calls the case People versus Annie Oglesby.
Good morning, Your Honor. Fellows of the people.
Where is she? Oh. See her. I thought she had enough yesterday.
Never. Never.
Your name, ma'am?
Annie Marie Oglesby.
Good morning, Your Honor. Tina Saxon for Miss Oglesby.
Okay, she's in. Got it. All right, thank you. All right. What are we doing?
Your Honor, there are now two cases. I just received the newest case yesterday. I don't have any discovery for that, but I did file my appearance and request for discovery yesterday. For the first case on this matter, I'm going to ask for an adjournment because there's an overlap between the two cases. It looks like it's coming out of two different jurisdictions, but for the same offense. So I'm asking for an adjournment so that we can track these together if the court is in agreement with that.
Yes, I will adjourn it. Currently, she's being, okay. Probable cause conference will be adjourned September 11th, 2025, 9 a.m.
Your Honor, since this matter, I have to ask for another date. I will be out of state, returning that day, but.
I can do the 18th. Will that work?
Yes.
September 18th, 2025, 9 a.m.
Your Honor, when approved, I'm sorry, there was a bond violation that.
Yes, there was. Pardon?
Your Honor, as you remember on the first violation, Ms. Oglesby was in custody. The second one, she simply did not have the money. She had lost her job while she was in custody in the other jail. And she couldn't pay for it, therefore they would not allow her to test. And now she's in custody again.
She didn't report for intake. So I don't know how that happened.
She stated that she called and left 2 messages with the community health and never received a phone call back.
Well, my understanding is she didn't report. We sent over another order. She again did not report for intake or testing.
Again, yeah, she lives in Jackson, which I stated.
Okay, that's like 35, 40 minutes away. And she.
Mr. Pawpaw, with regard to your motion for intervention in lieu of conviction, the court is going to deny that request. Mr. Harris.
Your Honor, my understanding is he is going to enter a guilty plea to the charge today of aggravated possession, felony of the 5th degree, and will proceed to sentencing today.
All right, Ms. Chambers, is that accurate?
Yes, that's accurate.
Okay, Mr. Pawpaw, they're telling me you're going to change your plea to 1 count of the indictment. Before I get to change the plea, I am required to go over some things with you. Okay, sir?
Yes, sir.
How old are you?
I'm 47.
How far did you go in school?
I have my GED.
So you can read and write?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
Has anyone promised you how the court would sentence you in this case?
No.
Has anyone threatened you in any way to get you to plead guilty against your will?
No.
Are you satisfied with the representation you've received from Ms. Chambers?
Yes.
Are you currently under the influence of any drugs or alcohol?
No.
Do you take medication that interferes with your ability to understand what's going on today?
No.
I have in front of me a document. It's called a change of plea. On page 3 on the line marked defendant, there is a signature. Did you sign this?
Yes.
Did you read this and go over it with your attorney before you signed it?
Yes, sir.
And you believe you understand what it says?
Yes, sir.
This document says you're entering a plea of guilty to 1 count of aggravated possession of drugs as a felony of the 5th degree. That carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. A prison term is not mandatory. Do you understand the maximum penalty?
Yes, sir.
You're also subject to a discretionary period of post-release control, which means that if you are sent to prison on discharge upon your release, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time you get sentenced to. Do you understand that?
Yes, sir.
But it's not mandatory that you're sent to prison at all. This court does have the discretion to place you into community control, what some refer to as probation. While on community control, you will have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes.
You are presumed innocent of this charge. You cannot be sentenced or punished in any way unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, the right to confront and cross-examine each of the state's witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's the right of compulsory process. Do you understand that?
Yes, sir.
You also have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense. And if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
You could also waive your right to a jury trial, but maintain all the other rights we've discussed. You can try your case to the court. I too would have to be convinced of your guilt beyond a reasonable doubt or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
Yes.
Do you understand that when you enter plea of guilty, you'll be waiving all these rights? We will not have a trial.
Yes, sir.
This is how you want to proceed.
Yes.
Mr. Harris.
Your Honor, if this matter had proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment, that on or about December 4th of 2024, Alan Pawpaw was found in possession of 1.45 grams of methamphetamine. This was after a traffic stop in the city of Lebanon, Warren County, Ohio.
Ms. Chambers, anything on those facts?
No, Your Honor.
Mr. Pawpaw, did you hear the statement that was read?
Yes.
Do you admit and acknowledge what he said is true?
Yes.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we discussed?
Yes.
What is your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. It's my intention to proceed with sentencing using the ILC assessment as a PSI. Mr. Harris, anything on behalf of the state?
Your Honor, he has 0 days of jail time credit. We're requesting $205 in reimbursement. That's to the Lebanon Police Department. Based on our in-chambers discussion, it's my understanding he is interested in recovery court.
Anything from probation?
Nothing further, Your Honor.
Ms. Chambers?
I did discuss recovery court with my client, Your Honor. Since the PSI or the ILC investigation has been done, he does have a job. He does have secure housing. He's still participating in his treatment. He understands that by doing general supervision, he still is likely to be sent to treatment, and he's fine with that, whatever level is determined that he does. But he doesn't feel that recovery court is necessary at this point in time.
Mr. Pawpaw, is there anything you'd like to say?
Just that I'm still going, I just had open heart surgery, and I'm going through, I have to go through regular checkups and stuff like that. And so they just released me to be able to start working, and I have found a job, and everything's starting to come back together. And
Where are you working?
Diamond Concrete in Xenia, Ohio.
Is that a verifiable job?
It's a 1099 job. I'm just kind of doing it part-time right now.
All right. Court's considered the statements made here today, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. The court will find that you are amenable to community control. So I'm going to place you in community control for a period of 3 years. You will be subject to the supervision of the Warren County Probation Department. You're ordered to refrain from the use of any drugs, alcohol, and there's no marijuana use in any form. You are ordered to continue to successful completion your current treatment. You have 0 days jail time credit. You're ordered to successfully complete the Thinking for a Change course. I will hold off on the recovery court at this time. But Mr. Papa, that's a program that offers you a lot more resources than it may ultimately benefit you. So I'll hold off on that now. The court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. So as long as you continue to do well, we'll hold off on that. You're also subject to a discretionary period of post-release control. Do you want me to go over that with you again?
No, thank you.
All right. I'm trying to think about the employment, whether I want him working full-time or not. How many hours a week are you working now?
Anywhere from like 20 to 25, somewhere in there.
How many hours a week are you in treatment?
I do that twice a week.
Is that group?
Yeah, it's a group.
How many hours is that?
It's only an hour at a time.
All right, I do want you to seek full-time verifiable employment. I think that would be beneficial to you. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. Do you have any questions?
The only thing, am I able to get driving privileges through you?
I didn't suspend your license, so the answer to that question is no, I don't have the authority to grant you privileges.
Okay.
Why is your license suspended?
They're just suspended until next month for driving under suspension. Or no, it was not keeping up with the insurance.
Yeah, I don't have that authority. I didn't suspend your license, so I don't have the authority to grant you privileges on that suspension. You'd have to go to the court that suspended your license, or if it's the Bureau of Motor Vehicles, you have to go to the municipal court in which you reside.
Okay.
All right. Anything else, Ms. Chambers?
No, Your Honor.
All right, your probation, head back down to court services. Your PO is going to want to meet with you this morning.
Thank you.
Thank you, Your Honor.
Thanks, Dora.
Thanks, Judge.
Hey, did you understand my response on that one mental health?
It is
case?
outpatient.
Yeah, marijuana use?
Yes, I did. Yeah.
Ready to. This is case number 25CR42853, the state of Ohio versus Paul Fisher. Mr. Fisher is before the court with his counsel, Ms. Chambers, Mr. Tranter on behalf of the state of Ohio. First, we need to place of record that I have a personal relationship with Mr. Fisher's mother and father. Mr. Paul Fisher Sr. is here in the courtroom. He does a lot that benefits my veterans in my veterans court. Is there any objection to me proceeding and presiding over this case, Ms. Tranter?
None from the state, Your Honor.
None, Your Honor.
All right, so just so you're all aware that I've disclosed that I am friends with Mr. Fisher's mother and father, so I don't want that raised and thrown back up at me. Mr. Fisher, they're telling me that you're going to change your plea to guilty to this one count of the indictment. Do you understand, because you've been before me before, that because I know your parents, that does not mean that you are going to get any leniency from me. I'm going to hold you strictly responsible for all of the orders that I issue. You understand that?
Yes.
And you don't want me to recuse myself? Okay. All right. So they're telling me you're going to change your plea to guilty to the one count of the indictment. Before I get to that change of plea, I need to go over some things with you. Okay, sir?
Yes, sir.
How old are you?
35 years old.
How far did you go in school?
I graduated high school.
Can you read and write?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
Has anyone promised you how the court would sentence you in this case?
No, sir.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation you've received from Ms. Chambers?
Yes, sir.
Are you
No,
Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take any medications that interfere with your ability to understand what's going on today?
No, sir.
I have in front of me a document. It's called a change of plea. On the second page on the line marked defendant, there is a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with your attorney before you signed it?
Yes, sir.
And you believe you understand what it says?
Yes, sir.
This document says you're entering a plea of guilty to one count of violation of a protection order as a felony of the 5th degree that carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. The prison term is not mandatory. Do you understand the maximum penalty?
Yes, sir.
In addition to that, you are subject to a discretionary period of post-release control, which means if you are sent to prison upon your release, the adult parole authority may supervise you for up to 2 years. If you violate those rules of supervision, you can be returned to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. Do you understand that? But it's not mandatory that you're sent to prison at all. The court does have discretion to place you into community control, or what some refer to as probation. While on community control, you'll have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that? You are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that? You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, the right to confront and cross-examine each of the state's witnesses. Do you understand that? You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that? You also have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you. I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that? The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense. And if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
Now, you could also waive your right to a jury trial, but maintain all the other rights we've discussed. You can try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've gone over?
Yes, sir.
Do you understand that when you enter a plea of guilty, you'll be waiving all these rights? We will not have a trial.
Yes, sir.
This is how you want to proceed.
Yes, sir.
Ms. Tranter?
On or about July the 6th of 2025, Warren County, State of Ohio, the defendant Paul Fisher did recklessly violate the terms of a protection order issued previously and did have a previous conviction for violating a protection order on July the 31st, 2018 in Hamilton County Municipal Court under case 18 CRB 19018.
Ms. Chambers, anything on those facts?
No, Your Honor.
Mr. Fisher, did you hear the statement that was read?
Yes, sir.
Do you admit and acknowledge what she said is true?
I do, sir.
And again, you understand all the rights you're giving up entering a plea of guilty, those rights we discussed.
Yes, sir.
What is your plea?
Plead guilty, sir.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we discussed. The court accepts your plea of guilty based upon the statement of facts in your plea. The court will make a finding of guilty. I'm going to order a new pre-sentence investigation. We'll come back in a few weeks and do sentencing at that time. I do know that the protection order has now been dismissed. So anything else, Ms. Tranter?
No, Your Honor.
Ms. Chambers?
Not at this time, other than I do know my client is interested in doing treatment. So whoever his pretrial services officer is can be made aware of that. I'll tell him that as well to kind of get that ball rolling.
Okay. All right. I'll see you in a few weeks.
Thank you.
Thank you, sir.
report twice.
She could not report the first time, Your Honor. She was in jail.
I was in custody in Eaton County.
Right.
So I understand your position, at least on the second time. She did not report for intake or test. I'm just providing the explanation for the failure to test. It's not free and they would not do it without it, but I understand your position on the intake.
It's considered a dirty job in Jackson if you don't have the money.
I don't know what that has to do with this. You didn't report to our community correction.
Ms. Oglesby, don't speak.
All right, I don't need a response. Motion for bond reduction is denied. Bond will continue. Thank you. Court calls case People versus Jeremiah Dillian.
Trevor Maybell for the people, Your Honor.
Good morning, Your Honor. J. Grant Miller, P58658, on behalf of Mr. Dillon, who stands to my right.
Your name?
Jeremiah Dillon. Your Honor, I was just appointed yesterday. I believe the people have withdrawn. Hopefully the court has the order and I filed my appearance. I did get the discovery in this matter, but I just met Mr. Dillon this morning in person. So we're asking for a 2-week adjournment to discuss the matter with the people.
Probable cause conference, September 18, 2025, 9 a.m. Bond continue.
Thank you very much, Your Honor.
Court calls case People versus Vincent Dunlap.
Trevor Maybell for the people, Your Honor.
Good morning, Your Honor. Laura Yagi, Assistant Public Defender, with on behalf of Mr. Dunlap, who's approaching. Mr. Dunlap, could you say your name for the court?
Vincent Dunlap. Thank you.
Your Honor, I apologize, but may we approach in this matter?
Yes.
Thank you. Thank you, Your Honor, for the bench conference. As I mentioned, I know Mr. Dunlap is eager for me to make a bond argument for his release. He was in treatment. I don't have that documentation. I'm going to follow up to try to get it. I obviously want to advocate for his release, but I know it's important to have the documentation verifying what he's saying, which is that he did actually complete the treatment.
I have another copy at the house.
So I'll follow up with Mr. Dunlap about that. In terms of the PCC, Your Honor, at this time, the prosecuting attorney and I have had some communication. There's no offer at this time, so we would ask that it be set for exam.
Discovery is complete.
To my knowledge, Your Honor.
People have their witnesses available on the 16th.
Yes, Your Honor.
Preliminary examination in person, September 16th, 2025, 9 a.m. That is before Judge Washington. At this time, bond will continue.
Thank you, Your Honor.
Court does call the case People versus Larry Atkins.
Calls for people.
I know, because she's not here. Your name, sir?
Larry D. Atkins.
Thank you. Where is Atkin ruling?
We're grabbing it right now, Your Honor.
Not forcefully enough.
Understood.
No, take your time.
Apologize. Assistant Public Defender, Shanazi Fairback, really, Your Honor, on behalf of Mr. Larry Atkins.
Mr. Atkins, have you already stated your name for the record?
Yes.
Okay. Your Honor, we are asking,
His whole story of his life by the time you got here, but go
I was
ahead.
gone that long. I'm sorry, Judge. We are asking for an adjournment in this matter to gather mitigation information.
You have a green sheet.
I do, Your Honor.
You're filling it out now?
I am, Your Honor.
Yeah. Probable cause conference will be adjourned September 25th, 2025, 9 a.m. Bond continued. Slow.
Thank you, Judge.
Thank you.
Thank you, this.
Court calls case People versus, is it Jakeeves Gully?
Name of the people, Your Honor.
Apologies. Laura Yagi, Assistant Public Defender with and on behalf of Mr. Gully. Mr. Gully, can you state your name for the court?
Jakeeves Gully. Thank you.
I apologize, Your Honor. We're asking for an adjournment. Mr. Gully indicated he's going to retain counsel or he's in the process of retaining counsel.
How long is that going to take you? 2 weeks. One adjournment for that purpose. Probable cause conference, September 18th, 2025, 9 a.m. Bond continued.
Thank you.
Court calls case People versus Jamie Bailey.
Laura Yagi, Assistant Public Defender with and on behalf of Mr. Bailey. Mr. Bailey. Mr. Bailey. Your Honor, I was going to request an adjournment. I have a green sheet. We did receive media discovery yesterday, and I haven't had time to review it with Mr. Bailey, so.
Because he's not here.
Apparently, is not.
That warrant will issue for defendant's failure to appear. Bond is set in the amount of $10,000 cash surety. That warrant will issue immediately. Yeah. Court does call the cases of the People versus Demond Harris.
Hello, Judge. Brian Bowling on behalf of Mr. Harris, who's approaching. Name for the record. Harris. Judge, I'm asking for an adjournment so that we can have some ongoing plea discussions in this matter.
Is this the only thing holding him, or?
No, there is other matters, Judge.
All right. Probable cause conference will be adjourned September 25th, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Court calls case People versus Christopher Minor. Custody.
Good morning.
Name of the people, Your Honor.
Good morning, Your Honor. Kelma Tadish on behalf of Mr. Minor. Mr. Minor, are you able to sit down on the chair?
Yeah.
Yeah, could you? I asked the wrong question. Thank you. Can you state your name for the record, please?
Minor.
Did you need his full name, Your Honor?
That's Mr. Minor. We'll go.
All right. We still have outstanding discovery, Your Honor. We were going to ask for an adjournment, please.
All right. Is this the only thing holding him?
No, it's not.
Probable cause conference will be adjourned September 25th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
All right. Thank you, Mr. Minor. Let's call the case people versus Dominique Kelly Payne. Dominic.
Assistant Public Defender Jay Bellinger on behalf of Mr. Kelly Payne, who approaches, Your Honor. Take your name for the record.
Dominic Kelly Payne.
And Your Honor, I have supplied the court with a waiver form.
Yes. Sir, you're waiving your right to a preliminary examination?
Yes.
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 You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant bound over to circuit court on counts 1 through 3 with 4 following.
Your Honor, people acknowledge, I'm sorry, not the people, defense acknowledges receipt of information, wait for reading and stand mute.
Defendant having waived for reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
September 16th at 1:30 with Judge Cook.
September 16, 2025, 1:30, Judge Conkey.
Cool. That'll be me, okay?
Good. Thank you.
Bond will continue.
Thank you, Your Honor.
Thank you. Let's call the case people versus Kayla Baird.
Assistant Public Defender, and I'll be carrying out really on behalf of Kayla Baird. Judge, can we pass this matter?
No.
Miss
Why?
Baird is present. I asked,
What?
she is here. I asked her to go to community corrections to test because she had not done so. So she's over at community corrections now.
She tested.
She lives in Flint now. She's currently displaced and she tells me that she lives in Flint and she did not have a way to get down here to test. Thank you, Your Honor.
Court calls case people versus Melissa Konwinski.
Chelsea Virgils with and on behalf of Melissa Konwinski, who approaches. Please state your name.
Mary Konowinski.
All right. What are we doing?
Your Honor, we're asking to adjourn to continue a plea discussion, and I would ask to address bond.
Of course you would. Is this the only thing holding her?
Yes.
Probable cause conference will be adjourned September 18, 2025, 9 a.m. Yes, to bond.
Your Honor, we're asking for a personal bond in this case. I understand she did have a violation, but she has a thorough plan to maintain sobriety, including through CMH, full substance abuse and mental health treatment. She has an appointment set up with them already, including also the vitriol shots involving with her church. She goes to AA. She's really worried about getting out to work. She supports herself financially. And I think that this plan can set her up on the right track. So we ask you to consider that.
What is the plan? That's the plan?
Yes, treatment, AA, church. I think all of those things would be a great support system for her. And she did just get out of inpatient treatment recently, so that is fresh in her mind. She wants a chance to show the court that she will comply.
She got out and then 2 days later, she's violating her tether.
It was admittedly a relapse that she deeply regrets.
Response from the people.
Your Honor, when we talked about this last week, I reminded the court that this was a hit and run with an alleged BAC of appointment to date. I'm not saying that Ms. Kominski is somebody that needs to be in jail indefinitely, but I do think that we'd like to see it a little bit more concrete in any release with this grandmother.
Your Honor, may I respond briefly?
Go ahead.
I just wanted to point out that the incident allegation in this case was before her inpatient treatment, so she sought out that treatment herself. We have no objection to a scram tether, but I think
Didn't
that this,
she have a program for follow-up care after her treatment?
I believe so. I think that part of
Is
this
she
plan.
following that?
Are you following your plan?
Yes, I am.
And I think this is fairly concrete. She has an appointment on September 22nd.
After she got out of treatment, she was supposed to, there's another part of what her treatment would be. Did she continue with that?
What was the plan after treatment?
The plan after treatment was to go into IOP, which I did call CMH, but unfortunately there was no opening until the 22nd, so I can have a 90-minute evaluation so I can get an IOP. I am still following up with
Michael Francis, which is an outpatient psychiatrist in the meantime, until I can get in there on the 22nd.
So the answer to my question is no, she didn't follow up with that. And then secondly, then again, 2 days after that, outside of the facts of the particular case, she was drinking again. So, and I'm not really hearing a concrete plan that's consistent with the inpatient that she received. So for those reasons, the court is going to deny the request for a bond. In this case, bond will continue. Court does call the case of the People versus Jennifer Baker.
Thoughts for the people.
Assistant Public Defender Jay Bellinger on behalf of Ms. Baker, who approaches, Your Honor. Baker, can you please state your name for the record?
Jennifer Baker.
Yes, you may.
For Ms. Baker's purpose, that if this case is dismissed, in fact, and I talked to the prosecution about that, you will not have to come back for the dismissal to issue. Okay? Is that correct, Your Honor? I just want to make sure that.
Sure.
Okay.
No, she doesn't have to come back because of the reason why there would be the dismissal. I wouldn't want to. All right.
Okay.
Thank you.
Okay.
So we will figure it out. Okay. All right.
Court does call the case People versus Demarion Makowski Smith.
Morning, Your Honor, Raymond Cook for the people. Good morning, Judge Fleischer on behalf of Demarion Makowski Smith.
Assistant Public Defender Alexis Zerbs, also with and on behalf Mr. Makowski Smith.
Good morning, Your Honor. Demarion Cortez Makowski Smith.
All right. What are we doing?
Your Honor, there should be a green sheet submitted. We are respectfully requesting an adjournment just to discuss his options with him. And to
Are these the only things holding him?
Your Honor, if we can make a minor request, he's currently awaiting an MDOC tether for a circuit court case that he's on probation for a home confinement tether. He saw the visiting judge for Judge Collin yesterday. He turned himself into the jail yesterday morning on that warrant, got that violation taken care of. They granted him the PR with the MDOC tether with home confinement. So we would be asking if the court would consider removing his tether for his bond on the CCW case, considering he'll already be monitored with the MDOC tether.
But we will get that information.
And that's what I was explaining to him, Your Honor. We just would make that request because it does seem a little redundant that he's going to be home confined twice.
And Your Honor, if I may add, Mr. Makowski Smith has been very communicative with me during my co-service representation. As soon as he was instructed to turn himself in, he called me immediately to let me know what he was doing and that he was about to turn himself in. So he's been very communicative, and I've every confidence that the court will be able to.
He's got 2 legs, so we can put a tether on each one.
Understood.
Is that right? I mean, I'm just saying.
That's what it have to be. That's what it have to be, Your Honor.
And understood, Your Honor. I did have that conversation with him as well.
If we can get communication from MDOC, I don't mind releasing ours, but I'm not going to release our tether until I have that assurance that we'd have the information.
Understood, Your Honor. We can see if that is a possibility.
All right, so that request regarding modification of bond at this time is denied, but if they get that information, then we'll figure it out. Okay? Thank you. Oh, it's the 18th.
Thank you, Your Honor.
Court does call the case People versus Taiwan Felon.
So I'm here appearing on behalf of Mr. Phelan. Hearing via Zoom. Mr. Phelan, will you state your name for the record?
I want Phelan.
Thank you, sir.
Your Honor, may we approach?
Yes.
Continued plea negotiations.
All right. Probable cause conference will be adjourned the September 18th, 2025, 9 a.m. Would that be enough time?
I think so.
All right.
Thank you.
Bond will continue. Court does call the case People versus Melvin Morrow.
Trevor, people around.
And Laura Yaki, Assistant Public Defender, with and on behalf of Mr. Morrow, who's approaching. Would you state your name for the court?
Melvin Morrow.
Your Honor, I apologize. I do have two documents, one signed exam waiver and one request that Mr. Morrow be released to treatment. I did provide a copy to the prosecutor.
It would allow him to be released to treatment.
Thank you, Your Honor.
He's waiving exam.
Yes, Your Honor.
That's correct, sir.
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count. Ms. Young.
We waive formal reading and stand mute, Your Honor.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
September 16th at 1:30.
September 16, 2025, 1:30 before Judge Conkey. Bond will continue.
Thank you, Your Honor.
Court calls case People versus Dominic Brewer.
Trevor Mayville for the people around.
On behalf of Mr. Brewer, who is here with me, can you please say your name for the record?
Dominic Brewer. Thank you.
Your Honor, we're asking for a 3-week adjournment so we can continue plea negotiations.
3 weeks?
Yes, if Your Honor is so inclined.
3 weeks? Why?
Because I'm on vacation and he has requested that.
So we all have to wait for you to get back?
No, I can do my work before my vacation
You're gonna do it before the vacation, then why am I giving 3 weeks?
because it's unrealistic that I complete what I need to do for his case before my vacation starts. Your Honor, I have full faith in my PD team that if it gets adjourned 2 weeks, that they'll do even better than I would on his case. But I'm just trying to get his
sweet.
request in. Yeah.
I doubt where she
Into a bench conference.
September 25th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thanks. Take care. Okay. Court does call the case People versus Megan Moses.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Ms. Moses, who approaches to my right. Ms. Moses, please state your name for the record.
Megan Moses.
Thank you.
Your Honor, today is the date time set for probable cause conference.
It is.
At this time, there was an agreement in place. So we're going to be asking for an adjournment of this probable cause conference and some consideration on bond later on.
Okay. How much time did you need?
Let's start with 3 weeks for the adjournment.
Okay.
All right. Did it go into the bond?
Yes, go ahead.
So, Ms. Moses, I believe she was here last week. She had turned herself in. She had issues both with her tether and being able to get a Zoom date. When she appeared here, there was a question about whether or not she had communicated with our office or with anyone concerning the issues she was having. The attorney who was standing in at the time, I don't think was able to let the court know that Ms. Megan had in fact been in contact. She did let us know. She did let us know that she had issues. We have file information from August 20th, where she contacted us concerning the issues she was having concerning her phone and her tether. So I understand that one of the things that the court was concerned about was that she did not have communication with us. And that's just not the case. She did communication with us. There are file notes that indicate that she did contact her office. More importantly, she did turn herself in. She came into her court date. She was here. She was present. So what we're asking is that not only that she be released from jail during this interim period, because part of what we're trying to do is to get her in a situation where she can pay restitution for this matter without giving away too much. So we want to be able to get her out, get her employed, and get her to making payments. And so that comes to the second part of what we're here to ask.
What day did she turn herself in?
Last Thursday.
Last Thursday. And she came here, she came to court and then she was taken into custody. She was remanded when she came to court. So she came here.
With the tethers.
Okay, because I think I did address most of that yesterday with the last time that we were here, but response from the people.
Your Honor, ultimately, leave it to the court's discretion. I can't say what communication she had with her attorney. Obviously, I'm not privy to that. My concern is I do think that she does need to be out in order to make that restitution, because that's sort of the contingent basis of this plea negotiation. Whatever steps the court feels it needs to take in order to monitor her. I have no objection to that, but I think that some form of release might be appropriate, given that we need to have that payment, because you can't do that in custody.
Right, but the problem that I'm having is typically one of the forms of doing that is to put somebody on a tether.
Right.
Somewhere she's had a problem with the tether. I don't have any information that the tether was defective in any way. She said it was something with her bike.
Yeah, she was on the bike and somehow it hit.
And the other problem is that I'll say maybe she misspoke, but regarding the communication and where she was vis-a-vis her mother when she was last here, because she said one thing and then switched that and said another. So that was another issue that I had with the story she was telling me.
So I wasn't here, so I'm not privy to what that was about.
So what she said is she initially said she called her mom. Mm-hmm. However, prior to that, it indicated that her phone was broken. And so that she couldn't call. Then she abruptly changed and said she rode her bike to her mom's.
So what she's telling me is that she did call her mother after the phone was broken, but she did that at a gas station. She had to ride someplace.
Where?
At a gas station.
It was a Walgreens, actually.
Walgreens gas station. So she had to go someplace.
So last time the story was told, we didn't have a stop at Walgreens.
It was a lot going on. I was
apparently
the story and I was nervous. So I was saying I called my mom and then I rode my bike, but it came out as I was misspeaking, but it was all together. I did call my mom and then rode my bike to her work. But it was at a gas station. It wasn't on my cell phone or anything.
Is that a gas station?
It was a gas station.
I thought it was a Walgreens.
Well, there was a Walgreens next to it, but there was a gas station Walgreens. It was like right there in Jackson on West Ave.
Didn't she just tell me she called from a Walgreens?
It was a gas station, Walgreens, like right there. Honestly, it was the Walgreens phone that I used.
At the gas station?
No, there's a gas station next to it. So it was, they're both, it's the same building.
Should we Google Mr. Jackson?
I'm not Googling anything. But
I'm just saying, that's where I stopped to call my mother.
okay, so here's what I'm gonna do, because I either you have a problem telling a story
I'm not.
or
Sorry.
you're not telling me the truth. So what I'm gonna do is I will adjourn this 3 weeks, and that is to September 25th, 2025, 9 a.m. At this moment, I will have her bond continue. You've got a lot of people, Mr. Brown. So if somebody can show me a building where there's a gas station attached to a Walgreens that she's in that area,
They're not
I will then, they're not attached.
No.
Of course not, they're not.
We will
my
Google it and we will have a picture sent right away to the court.
If you show me something that makes this story make sense, because this is now an added piece. He's at a drugstore calling. Who are you looking for? Who's gonna have to do it?
Oh, I'm gonna get one of our fine fellows.
I know, but which one? So that when it doesn't happen.
It was West Ave.
Oh, you guys get paid too much to do this. Oh.
It could have been a CVS.
Shanaza, you can't even appear for your case and now you're all in this. What? It's not it's a CVS? So it's not even a Walgreens.
I was in there was a lot going on, honestly.
I know.
I was in a panic, so I can't remember even where I called from. I'm pretty sure it was the Walgreens or CVS.
Okay, we're not gonna sit out here while you look at the computer. I've made my order. They can then, what?
The CVS right here, I think. Thank you.
Approach prosecutor. Show it to the prosecutor. Is it a Walgreens or is it a CVS? She doesn't even know what drugstore she's in.
Wait. This is not Jackson.
That's not where.
That's not even Jackson.
Yeah, I know.
Jackson, Michigan.
Right? They were gonna show me some fake Google picture.
No.
No, I know what was in there. Okay, I don't. All right, I've made my ruling. You guys can show this to me. She'll get released if I get a picture of the real place.
We got you, Judge. We're on it.
No AI, none of that, Mr. Brown. I know you don't even know what that is, so I'm not, but I'm worried about them. Don't, Shanaza, get out of this case. What are you doing?
I'm looking at my case, Judge.
We got you. We got you, Shanaza.
And you. Up top, but I don't know who it is.
Oh.
Can you ask her?
There's an individual from MDOC, the Women's Huron Valley. Can you state what your name is? I think she's frozen. Appears to be who?
Miss Johnson.
Valerie Johnson.
Okay. So court does call the case People versus Valerie Johnson.
Again, Your Honor, reading the people.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Johnson. Ms. Johnson, will you state your name again for the record?
Valerie Johnson.
Thank you.
All right, I do have a plea form in front of me where she's going to plead to the charge, count 2 of use of a controlled substance, a 1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
That is correct, Judge. And for the record, I did speak with Ms. Johnson this week. I did review the advice of rights form with her. She did give me permission to sign that as well as the plea form on her behalf.
All right, thank you. Johnson, can you raise your right hand, please?
Yes.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name again for the record, please.
Valerie Johnson.
Okay, you can put your hand down. Ms. Johnson, it's this court's understanding that you're going to plead guilty to the charge of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that?
Yes,
All right. Still wish to plead guilty?
yes,
And to that charge, how do you plead?
guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes,
You signed an advice of rights form or went through that and gave your attorney permission. Is that correct?
correct.
Did you have any questions regarding any of the rights on that form?
Weird man up. Stuff was found in my house. Greg's gun was there. Greg called me. Yeah. After I found the gun, he called me and said, "I'll go to court with you and tell you that this represents a gun." Well, the last minute he failed to come because you know why? I think he's not going to come because the gun might have been stolen or something. He's going to get ambushed. I don't know what his excuses are. Your Honor, it wasn't my gun, but yes, it was in my house. So I stand before you to accept responsibility for it.
Anything else? All right.
I don't know what to say, Your Honor. I'm sorry. I'm sorry to be here. I'm sorry to be a part of it.
All right, courts consider the statements made here today, the pre-sentence investigation, the purposes and principles of sentencing, the relevance, seriousness, and recidivism factors. Mr. Noble, even if you were set up on the original charge when paramedics arrived at your house, you were then on when they went to arrest you on that indictment on September 26, 2024. They literally find the same drugs in your house.
Yes, sir.
Methamphetamines. Methamphetamines has no medical purposes.
No.
It is a illegal recreational drug that has no medicinal purposes. You understand that?
Yes, Your Honor.
Okay.
What I was doing was using it for pain relief, and there was no excuse for it.
Well, you had quite a large quantity based upon this
That I don't
indictment.
know well, she came in a couple of days before and brought me chicken soup, and I'd been through the house trying to find a place, trying to find everything, to get everything out of it.
Okay. On
I'm sorry. I'm
case
sorry.
number 42027, the court is going to order you on count. Sorry, Dina. I lost track of my counts here. On count one, the court will order you to serve a minimum term sentence of 6 years, maximum term sentence of 9 years. On the 1 year gun spec, the court will order you to serve 1 year in prison. By law, that is required to be served prior to and consecutive to count one. And on count three, the weapons under disability, the court will order you to serve 12 months in prison. That too to be served consecutive to count one. Is there a spec on the count three as well?
Probably just the forfeiture spec. Yeah, just the forfeiture spec.
Forfeiture spec. The gun is ordered forfeited. The court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. You have 9 days jail time credit on that case. Under case number 42359 on count one, the court's going to order you to serve a minimum term sentence of 6 years, a maximum term sentence of 9 years, that to be served consecutive to the time in 42027. And on count three, the court's going to order you to serve 6 years in sentence, that to be served concurrent with count one. Again, the court will find you have 0 days jail time credit on this case, and will find that you're indigent for the purpose of any fines, costs, or other financial sanctions. Court finds that consecutive sentences necessary to punish this defendant. It is not disproportionate to the conduct or danger posed by the defendant. And the second indictment was, the second offense was committed while the defendant was already indicted by the Warren County Grand Jury and was awaiting that case. Court has found him indigent for the purposes of fines, costs, or other financial sanctions, including the mandatory fine. You're also subject to a mandatory period of post-release control on these cases. Upon your release, the Adult Parole Authority will supervise you for a period of up to 3 years, but not less than 18 months. If you violate the terms of that supervision, you can be returned to prison for up to 1/2 of this court's original minimum term sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. These being mandatory prison sentences, you are not eligible for good time credit with regard to the Reagan-Tokes cases. You will be released by the Department of Corrections when you finish your minimum term sentence, unless the Department of Corrections determines that you must remain in prison for bad conduct. The court is not involved in that decision. If you're not released when your minimum term ends, you'll serve an additional specified period of time, and given a new release date, you will serve until that date. Unless you are again denied release, the process could repeat until you are released or you finish your maximum term sentence. You do have a right to appeal the court's decision if you're sentenced to the 12th District Court of Appeals. If you want to appeal, you must file your notice within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including counsel, that can all be provided to you at no cost. Ms. Tranter, is there anything else?
No, sir. Thank you.
Mr. Harden?
Your Honor, the sentence on the weapon under disability was 1 year consecutive.
1 year consecutive.
Thank you.
Your Honor.
So I got 14.
Yes.
14 to 17.
Correct.
Anything else, Mr. Harden?
No, thank you.
All right, at this time, Mr. Noble, there's a deputy standing behind you. You are being remanded into the custody to the Warren County Sheriff for transport to the Department of Corrections. Did you have a question for me, Mr. Noble?
I just want to thank you.
All right, thank you, sir. Good luck to you.
You want her to have it?
No,
Under paragraph 5, those are your trial rights. You understand that you'll be giving up those rights as well as all the rights that are contained on that form.
yes,
You understand you're giving up your right to appeal of right.
yes,
You on probation or parole? You're not.
no,
You're incarcerated. All right. Has anybody promised you anything other than what's been stated here today to get you to plead?
no,
Anybody threaten you or coerce you?
no,
You're doing this voluntarily and of your own free will?
yes,
And because you believe that you are indeed guilty of this offense?
yes,
On the date of September 26, 2023, at the Huron Valley Correctional Facility, did you have fentanyl in your possession?
yes,
Had you used it?
yes.
Did you know what you were using was fentanyl?
No, I thought it was Hillron.
Okay, you thought it was some other drug. You thought it was
Yes.
heroin, but it was
Yes.
fentanyl. Is that correct?
Yes.
Okay. I think either way. it doesn't- Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is satisfied, Judge.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Ma'am, is there anything you want to say before I do impose sentence?
Your Honor, if I may
No.
speak on Ms. Johnson's behalf?
Sure.
Your Honor, I did have a chance to speak with Ms. Johnson. This offense happened 2 years ago. At the time, she was grieving the loss of her mother, was unable to attend her mother's funeral. Since then, she has enrolled in treatment in the Michigan Department of Corrections and is currently on a MAP program. She does have her earliest parole date is not till 2033. So I'd ask the court to impose minimum fines and costs.
All right. I'll impose $125 state fee, 365 days in jail, credit 365, sir. Thank you.
Thank you, Your Honor.
Good luck to you, Ms. Johnson.
Thank you.
Court does call the case, People versus Eric Buckner.
We're ready. Laura Brown, Deputy Chief Public Defender, being ready on behalf of Mr. Buckner, who approaches the podium. Mr. Buckner, state your name for the record.
Eric Buckner.
Thank you.
Your Honor, today's the date and time set for a probable cause conference. At this time, we are going to respectfully request that the matter be set for a preliminary examination.
Both cases.
Yes, please.
The discovery is complete on both cases.
Yes, sir. Best of our understanding, it is.
People have their witnesses available on 16.
Yes, sir.
Preliminary examination in person will be set September 16th, 2025, 9 a.m. That's before Judge Perry on both matters.
Thank you, Your Honor. May we address the issue of bond?
Okay. Go ahead.
Thank you, Your Honor. So the last time we were here, we wanted to make sure that Mr. Buckner could take care of both employment needs, maintenance needs, and hospital appointments. He had medical appointments. He's got an arm that is deteriorating, so he needs to be able to have MRIs. You tasked myself and the prosecutor to try to get together and work something out. At the time, we had indicated that for employment, he was doing deliveries, but he didn't have any hours. So he asked us to be able to get together, work those out, and then provide an order to the court. We were unable to do that because up until recently, Mr. Buckner was unable to give us specific hours for the employment that he needed to do, for the deliveries. But you did say that as long as he let community corrections know when his appointments were, that he could go ahead and do that, and we put that in order. A development since then is that they told him that he cannot do the MRIs he needs to do with the tether on. Somehow that interferes. So what we're asking is for two things. First, that he be allowed to be able to remove the tether when he goes to do his medical appointments, so that they don't interfere with the MRIs that he needs to be able to do. Second, that he have 4 hours per day, either from 8 to 12 in the morning, or from 1 to 5? 5 to 9. I'm sorry, 5 to 9, so that he can be employed. He has to be able to be employed. He's got a daughter that needs to maintain, a house that he needs to maintain. He's out on home confinement because the court obviously didn't feel he necessarily needed to be in jail. But if he's going to be out of jail, he's got to be able to maintain himself and his family. So we're asking not that you release him, not that you not have any oversight, but that he just be allowed to be out to be able to work while he's on home confinement, and that he be allowed to have substantive medical care.
Response from the people.
Your Honor, I don't want to get in the way of that. I just haven't seen any documentation related to it. I know that defense counsel states that he had previous conversations with the last prosecutor, at least as it relates to the medical. Certainly don't want to object to that. I'd ask for documentation related to employment prior to allowing that out there.
We did that numerous of times with that, so
You sent me a list of hours that you need, but asking for something from there.
I've been on tether for a whole month, so we've been trying to figure this out. I don't know.
We don't be talking now, because you and I are talking. We're talking so that the court can't hear us. So don't do that. So what they're asking for.
We're not going to have an issue with the medical, provided the appointment is provided.
Right.
The tether needs to be removed for that purpose. That can happen, and I'd sign an order to that effect. Still worried about this employment, giving him sort of this window to, oh, he's gonna have that attitude when he just asked him to follow that instruction. Oh, we're not doing that. Motion for bond reduction is denied. I'm done. You talk to your client about why that just happened. My bailiff tells him something, he needs to just respond appropriately, not give that face. Oh, no, I'm done. Thank you.
Thank you, Your Honor. We will have whatever sufficient orders the court needs.
Court calls the case, People versus D'Angelo Simmons. Better check himself and don't slam my door. Oh, is this Mr. Brown also?
Yes. Assistant Public Defender on behalf of Hannah Apple on behalf of Mr. Simmons. Please state your name for the record.
D'Angelo Simmons. Yeah.
This is a competency.
Is the report back?
Yes,
Judge?
the report is
Okay.
back. It's in August, dated August 19. Don't know why. And it is finding that the defendant is competent to stand trial.
We would stipulate to that report, Your Honor.
All right. Court, having reviewed that report, would find the defendant is competent to stand trial, specifically that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. I do have an order that was submitted by Mr. Brown to that effect to the court, or proposed order. I'll sign that. Would you like this? Would you like this now set for?
Your Honor,
Oh, you're back.
Oh, hello.
No.
Lauren Brown, Deputy.
It was more of a pleasure dealing with Apple, but go ahead.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Simmons. Your Honor, we are respectfully requesting this matter be set for probable cause conference so that we can have some kind of substantive conversation with our client.
Is this the only thing holding him, or is he?
I believe this is the only case.
Okay, so I'll set it for the 18th.
Thank you very much.
September 18th, 2025, 9 a.m. Bond continues.
Thank you. We'll talk.
You saw that. Court does call the case, People versus Dale Miller.
We're ready in that matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Miller, who appears by video. Mr. Miller, could you please state your name for the record?
Dale Joseph Miller, the Alpha and Omega.
Okay.
Your Honor, the reason we are here today is this was set for a probable cause conference. However, Mr. Miller is undergoing competency evaluation and other matters.
What? No, go ahead.
So you guys can find out that's so funny pretty soon.
I am informed of that.
Yes.
And we have, is there a competency order for this file?
Yes,
yes, I do have it. All right. So what I will do
On
is
top
I
of
will
things.
order competency on this file. I will set it. I think those are set for November 6th.
Yes, so we'd ask Mr. Miller, just as we spoke, we're going to ask that this matter be joined with the other matters.
So I will set this for November 6th, 2005, 9 a.m. This time his bond will continue. Thank you.
Thank you very much, Your Honor.
Court calls case of the People versus Kevin Burton.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Burton, who approaches, Your Honor.
Kevin Burton, sir.
Thank you.
And Your Honor, today we'll be entering a plea. I believe the court is in receipt of everything that it needs to have.
Let's see. Yes, I did that.
And I apologize. There is a adjournment sheet there as well.
That's okay. I have a plea form that indicates that the defendant would be pleading guilty to the charge of aggravated assault, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed, and that the prosecutor will be recommending to the sentencing judge, prosecutors deferred. That's the court's full understanding.
That is our full understanding as well, Your Honor.
All right, may I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Kevin Burns, sir.
Sir, it is this court's understanding that you're going to plead guilty to the charge of aggravated assault. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court cost. You
Yes, sir.
understand that?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that?
Yes, sir. Yes.
Plead guilty
Yes, sir.
to that charge. How do you plead?
Guilty, sir.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
Or you signed an advice of rights form, is that correct?
My attorney has. I signed it with his permission, Your Honor.
All right.
Yes, sir.
You went through that advice of rights form, is that correct?
Yes, sir.
All right. You have any questions regarding any of those rights?
No, sir.
Please look at, there's a copy on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights of the court.
I do.
You understand you're giving up your right to appeal, all right?
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
Yes. Or no. No, no one's promised me anything.
All right, let's get that straight. Has anybody promised you anything else other than what's been stated here today on the record to get you to plead since this charge?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily
Yes, sir.
of your own free will
Of my own free will, sir.
and because you believe that you are indeed guilty of this offense?
Yes, sir.
On July 13, 2024, at the location of 3421 Platte Road, Apartment 12, City of Ann Arbor, Washtenaw County, State of Michigan. What did you do on that date involving an Angela Middleton that makes you think that you're guilty?
Threatened her, sir, with a hammer, sir.
Okay, you had a hammer in your hand?
Yes, sir.
And you were in close proximity to her at that point?
Yes, sir.
And you threatened her with the hammer?
Yes, sir.
Did you say something that threatened her with the hammer?
Yes.
What'd you say?
Can't recall, but I said something threatening.
You said something that led her to believe that you would use that hammer
Yes,
against her.
Yes, sir.
Would that be correct? All right. Either way. Sir, I would have to advise you that after I accept your plea and after that time, between that time and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and you also would, the court would not be bound by any sentence or agreement or evaluation. Do you understand that, sir?
I do.
Counsel, are there any other promises, threats, or other inducements which have led to this plea?
None, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Sentencing in this matter will be
September 23rd at 9 a.m.
September 23rd, 2025, 9 a.m. That's before Judge Valvo. Bond will continue.
Thank you very much, Your Honor.
Thank you. Court does call the case People versus Catherine Stiles.
Jackie, Assistant Public Defender, with and on behalf of Ms. Stiles, who is approaching.
Okay,
Catherine Stiles.
thank you.
And Your Honor, I do have a stipulation and proposed order for release to treatment for Ms. Stiles with the tether. The prosecuting attorney did indicate that she would stipulate if Ms. Stiles was released to treatment with the tether. Yes, sir.
All right.
Sorry, as to the substance of the PCC, I did not fill out a green sheet because Ms. Stiles wanted to request that this matter be continued to exam. However, and when I inquired yesterday, I think there wasn't media discovery. There may or may not still be outstanding discovery. So that's where we're at.
Yes, Your Honor. So our office did request the police on August 27th video. They hadn't provided it to us, and they've not provided us any video. there was an officer who responded to a store. And so I'm just gonna confirm that there's no video there, but we did ask.
All right. You would not be entitled to an adjournment if that existed not. You understand that, ma'am, if you want to proceed to exam?
Because the prosecuting attorney has given us all the discovery they have, if there's something else, we can't ask to adjourn it because at this time, we're saying that that's all they have. Does that make sense?
Yeah, absolutely.
People have their witnesses available to 16. Preliminary examination will be set September 16, 2025. Judge Washington. Bond will continue.
Thank you, Your Honor.
Move before the 16th.
Thank you.
Whoa. This is. Where's the gas? This is the gas station? That's the, they're not attached.
Your Honor,
There's a road in between,
she's my
like
client.
a big road.
My client is not as eloquent as you, Your Honor, when it comes to describing things. Now, we could get her some writing classes so she could learn to paint word pictures, but it is on West.
Hold on a moment. No. You're a very good attorney. You are not going to spin this. She told me the Walgreens, and it's not a Walgreens, it's a CVS.
I mean, she did say it was possibly a CVS, though.
One's red, one's green. Okay. She said the gas station was attached to the Walgreens.
Well,
there's a road.
Maybe it just got built.
No, there's a road.
Is it a newly paved road, Your Honor? It's a brand new road.
Here, no, I'm not recalling it. You can let your client know. I did look at the map.
Yes.
Story still doesn't make sense. Her motion for bond reduction still denied.
Thank you.
But thank you for the pictures.
Thank you.
I would have done the AI, Mr. Brown. Court calls the case People versus Montez Miller.
Assistant Public Defender Jay Bellinger on behalf of Mr. Miller on case ending in 1435, Your Honor.
And Edward Lucas on behalf of Montez Miller in 1434.
You both are requested. And your name, sir?
Montez Miller.
Thank you.
Your Honor, I did be put before the court an order for release to treatment. I'm hoping that the court will sign that so that he can find a bed as soon as one becomes available. Otherwise, we don't have any discovery on this case, so we'd be asking for an adjournment.
I'm just asking for an adjournment for video purpose.
Get these together. Is this the only thing holding him?
I think there's some nominal bonds in these two cases. I think there is a circuit court case that
he's got a violation up in circuit.
Got it.
Sir.
Probable cause conference, September 25th, 2025, 9 a.m. Bond will continue.
And Your Honor, as to the order for release to treatment.
Oh, I'll sign the one that Mr. Duke is. I'm not signing it. No, I signed it.
Thank you.
Appreciate it, Your Honor.
Thank you.
All right. Thank you, sir.
Okay.
I want everybody to drive around and I will call somebody's cases. I'll give somebody a reward where there's a pharmacy hooked to a gas station. If somebody shows me one of those, I'm just saying. Those seem like two incompatible uses, but maybe I'm wrong. Court does call the case of People versus Tiffany Cash.
Assistant Public Defender Alexis serves with an on behalf of Ms. Cash and should be present via Zoom.
Bless you. Ms. Cash?
Perhaps she got up to use the restroom, Your Honor. Ms. Cash, can you please unmute and state your name for the record?
Think she can hear you in the restroom or what?
Your Honor, may we briefly pass this?
You enacting ruling. You're pushing it. Court does call the case People versus Justin Straight. And I've got a DOC.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Straight, who approaches. Mr. Straight, can you please state your name for the record?
Justin Straight.
And Your Honor, I am asking for an adjournment. Although we are now in receipt of the media discovery, I have not had time to go over that with my client. However, I do understand that the court did sign an order for release to treatment over the last few days.
Yes.
Please.
He did. Okay. So they have it already. So they're good to go. Okay.
So I can get in?
Yeah.
Thank you.
Good. Very good.
So this is the only thing holding, well, he's got a bond violation on this one, but this is the only thing holding him.
As far as I know, Your Honor.
Probable cause conference, September 25th, 2025.
You should be in it. You should be 9:25.
Bond
Should be in bed by then. Okay.
Thank you.
9:25 is your next day.
I'll be in bed.
You should be in it.
Court does call the case People versus John Coffey.
As both people.
Pardon? Mr. Coffey?
Yes, sir. Sorry about that, sir.
All right.
Did the prosecutor, okay, can I on behalf of Mr. Coffey? Mr. Coffey, can you please state your name for the record?
John Joseph Coffey Jr.
I have before me the two files that he is going to be pleading guilty to the charge of retail fraud in the third degree on each case.
That's correct, Your Honor.
That's correct, Your Honor.
That's the court's full understanding of the. Mr. Coffey, can you please raise your right hand?
Yes, sir.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name again for the record.
John Joseph Coffey Jr., sir.
All right, you can put your hand down. Sir, starting in case 25-1118, says court's understanding that you're going to need to be someplace stable, sir.
Yeah, I'm stop moving. Sorry about that, sir.
Maybe you could sit down, yeah, or stop walking.
All right.
Thank you.
Sorry.
Starting in case ending in 1118, it says court's understanding that you're going to be pleading guilty to the charge of retail fraud third degree. And likewise, in the other case ending in 1272, you're also pleading guilty to the charge of retail fraud in the third degree.
Yes,
Those
sir.
are misdemeanor. Those are misdemeanors punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased if 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, sir.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Fleischer in the 14A3 District Court.
Sir.
You understand that?
Yes, sir, I do.
All right. Understanding all of that, do you still wish to plead guilty?
Yes, sir.
Again, starting in 1118, 8, to the charge of retail fraud, 3rd degree, how do you plead?
Guilty, sir.
In case 1272, to the charge of retail fraud, 3rd degree, how do you plead?
Guilty, sir.
All right, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
I gave my lawyer permission to sign it.
And you went through that advice of rights form?
Sir.
Do you have any questions regarding any of the rights contained on that form?
No, sir.
All right. You understand that you'll be giving up your rights, specifically the trial rights defined or described in paragraph 5.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation? Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Has anybody threatened you or coerced you in any way?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you are guilty of this offense in these cases?
Yes, sir.
Starting again in the case ending in 1118, on the date of April 2nd, 2024, at the location of 1103 South Main Street, City of Chelsea, Washtenaw County, State of Michigan, what'd you do at the Ace Hardware that makes you think that you're guilty?
I took some power tools that were for sale from the company and went past the point of sale.
Okay, so you went in, got power tools, tried to walk out of the store without paying for them?
Yes, sir.
At the time, was the store open to the public at the time?
Yes, sir.
Did you have anybody's permission to take that property?
No, sir.
And this was property that was offered for sale by Ace Hardware?
Yes, sir.
In the other matter, 1272, I can complain on that. Give me one. All right. In that case, on the date of February 25th, 2024, at the location of 5645 Jackson Road in Scioto Township, Washtenaw County, State of Michigan, what did you do at the Meijer that makes you think that you're guilty of that offense?
I went in the store to try to take merchandise that was there.
All right. Store was open to the public at the time?
Yes, sir.
You didn't have anybody's permission to take that property, did you?
No, sir.
And the property you took was property that was offered for sale by Meijer?
Yes, sir.
Sir, I do have to advise you that if I accept your pleas on these cases and you commit misconduct as defined under the Michigan court rule between the time of this plea and the time of your sentencing, you would not be the court would no longer be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir, I do.
You also understand you would not be entitled to withdraw your plea.
Yes, sir.
Is counsel aware of any other promises, threats, or other inducements which have led to these pleas?
No, Your Honor.
I didn't hear a prosecutor. Ashley.
No, Your Honor.
All right, and has the court complied with the court rule and would be proper to accept its defendant's pleas?
People are satisfied.
Defense is satisfied, Your Honor. Thank you.
Court will accept the defendant's pleas of guilty to count 2 in each of these cases. Count 1 in each case is dismissed. A pre-sentence investigation and report is ordered at 1483 probation. Sentencing in these matters will be set for November 3rd, 2025, 9 a.m. before Judge Fleischer.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Bond will continue. Thank you, sir.
Thank you.
Case of the people versus Delco Thomas.
Alexander on behalf of the people.
Lauren Brown, Deputy Chief Public Defender, appearing written on behalf of Mr. Thomas. Mr. Thomas, please state your name for the record.
Delco Thomas.
Thank you, sir.
Your Honor, today is the date and time set for probable cause conference. We are respectfully requesting this matter be set for preliminary examination.
All discovery has been done.
Best of our knowledge, Your Honor.
People have their witnesses available the 16th.
We'll do our best, Your Honor.
Preliminary examination in person will be set September 16th, 2025, 9 a.m. That is before Judge Perry.
Let's do this.
Bond continued.
Thank you very much.
Thank you. Court calls case People versus Alicia Cargill.
Good morning, Robert J. Kilwall on behalf of Ms. Cargill. Ms. Cargill, would you state your name for the record?
Alicia Cargill.
Thank you.
Your Honor, here's where we stand on the situation. I met with Ms. Cargill at the prison on August 20th. We went over the police report. Co-defendant that previously pled to a misdemeanor. I believe I was offered that. Ms. Cargill wants to see the video of the incident. I have to make special arrangements with the prison in order to bring a computer into the Huron Valley prison. I need more time. I'm asking if I could have 3 weeks so I could make those arrangements.
I will cause conference with that objection will be set October 2nd. No, I don't have the October 2nd date. Right. I don't have October 2nd, so I meant September 30th, 2025 at 9.
Thank you, Judge.
Thank you, Bond. Continue. Court does call the case People versus Brandon Jackson.
Good
morning to this honorable court. Carla Marable, P number 6755 on behalf of Mr. Jackson.
Your name?
Brandon Jackson.
Thank you. All right, what are we doing on this case?
Your Honor, I am now in receipt of discovery. There's a co-defendant in this case, and I'm representing him too. They have wage conflict. We're asking that it be set for a preliminary exam.
Who is the co-defendant?
He was up last week, Your Honor.
When did we set the? When did we set the?
Jackson. We haven't set one yet.
When did we set that preliminary examination?
Your Honor, I'm not seeing that it was set for exam. The note that I have, I wasn't present for that, but I see that it was adjourned for a probable cause conference on the 11th.
Okay, so you want this one set for exam and then next week you're gonna set the other one?
Correct, Your Honor, and I apologize for interrupting you. I'm so sorry.
No, it's okay.
Yes,
Okay.
because at the time, we didn't have discovery, but we have discovery now. It was sent out late yesterday.
Okay, did you wish these or is there gonna be a problem if they're heard on the same day?
I think that the prosecutor's gonna want them on the same day, Your Honor.
That's nice of you to concede to what they want. I've never seen that before.
But I mean, I prefer for them to be on the same day. I think it.
Yes, all right, very good. Yes.
I was going to say it would work if they're on the same day, but I'll defer to the court.
All right. And both individuals are in custody?
Yes.
All right. Well, I guess I could set them for the 16th. And then that other one, that would just be short notice, but you'd have to let me know to set it for the 16th so they don't remain in custody. Will that work for you, counsel?
No, I start a trial on the 15th.
All right. My next day, then it's the 23rd.
That
I have
works,
the 23rd will work?
Yeah.
Okay. So I will set preliminary examination in person, September 23rd, 2025, 9 a.m. before Judge Fleischer.
Thank you, Your Honor.
Thank you. Bond will continue in this case. Thank you. Thank you, sir. Thank you. Court does call the case People versus Jermaine Dalton.
And then on behalf of people, Your Honor.
Brian Bowling on behalf of Mr. Dalton, just state your name for the record.
Jermaine Dalton.
Thank you.
Your Honor, we're asking this matter be set for an exam. I believe all discovery to be complete.
And would the people have their witnesses available to 16?
We'll do our best, Your Honor.
Paperwork, yeah. Preliminary examination in person, September 16th, 2025, 9 a.m. That is before Judge Washington. Bond will continue. Thank you.
Thank you, Your Honor.
Court does call the case of the people versus David Davis.
Trevor Mayville for the people, Your Honor.
Assistant Public Defender Hannah Apple appearing on behalf of Officer Davis. Mr. Davis, will you state your name for the record?
David Davis.
Thank you. Your Honor, I am asking for an adjournment for plea negotiations, and I do have information regarding the bond violation that I want to address with the court.
Yes.
Okay. Your Honor, I did receive that yesterday. I contacted Mr. Davis. We went through that. I will note he's on a scram tether. My information that there's been no violation. I, of course, assume that the court's biggest concern is this positive test for cocaine. The first one, Mr. Davis is forthcoming. I mean, he does not disagree that both tests are positive for cocaine. He does not deny use prior to being arraigned. But of course, that second test on the 21st is of issue. Mr. Davis is taking this matter very seriously. He is employed. He did reach out to Dawn Farms yesterday to enroll in outpatient treatment. I did provide documentation to opposing counsel, confirming that he did a screening and confirming that he is scheduled for his assessment on Friday, September 12th at 11 a.m.
But he doesn't have a medical marijuana card either.
No, and he reports that he has stopped use. I don't know. I think that's roughly like 3 weeks. I don't know if that's, or maybe actually less than, yeah, about 3 weeks if that is still in his system or not. But he reports that he has stopped THC use. But I think at this point, he at least, I would point out that he's had at least one test that he did not test positive for cocaine. He's on the scram tether, confirming that he's had no alcohol use. And he's working on getting into treatment and doing the right thing and showing the court that
he's not in treatment.
He has intake scheduled for the 12th. He did an assessment yesterday. He's beginning outpatient on the 12th next Friday.
I will adjourn his probable cause conference to the 11th, 2025, 9 a.m. But prior to his intake, defendant's remanded to the Washington County Jail. Bond is revoked.
Understood. Your Honor, would you like a copy of the confirmation of his treatment for the file?
Why don't we bring that up on the 11th?
Okay.
Okay, because I just don't want to keep it in here.
Sure.
If I don't have.
I'll do that. Thank you, Judge.
Court calls the case of the people versus Enrique Davis.
And then on behalf of the people.
Ready, Judge? Court shall feature Assistant Public Defender on behalf of Mr. Davis, who is approaching the podium. Mr. Davis, please state your name for the record.
Eric Davis.
Thank you. Thank you, Judge. I have had a chance to email the prosecutor and fit Mr. Davis. He is hopefully get this matter resolved, but he is not quite ready yet. We're still negotiating a resolution, and we have a 2-week adjournment.
Probable cause conference will be adjourned to September 25th, 2025, 9 a.m. Bond will continue.
9 a.m.
You sign up. Court does call the case of people versus Rayshawn Dawson.
I've read that on behalf of Mr. Dawson. Can you continue for the record?
Rayshawn Dawson. Thank you. How are you?
We're just going to be asking for an adjournment, Your Honor. As long as.
Around your vacation.
No.
No, that's what I heard. Don't worry about it. We'll get to you when we can, right? Okay.
It could be 2 weeks. It doesn't matter.
How long did you need for it?
2 weeks is okay, Your Honor. It need not be 3 weeks.
Well, I'll do this September 25th, 2025.
Yeah,
You wanted 2 weeks, but the other one you didn't.
I'm just
'Cause you're
following
gonna be
my
gone.
client's asking.
So what, you don't like this guy as much as the other one?
I do.
What? Is that what it is?
Again, I have
You were just
full
gonna
trust-
send him to somebody else? Is that what was gonna happen?
It was just a client's request.
And oh, you're blaming him.
No,
He's not going on vacation.
not. You're right. It'll be my pleasure to handle you on the 25th.
Nice save. September 25th, 2025, 9 a.m. Bond will continue. Thank you, sir. Court does call the case, People versus Sean Beater. Sorry, got it.
And my doctor on behalf of Mr. Veeder. Mr. Veeder, can you please state your name for the record?
Sean Visa.
You're gonna adjourn.
We are, Your Honor. There is a competency that has been ordered in 15th District Court. I have just learned about that. I am going to submit an order for this.
This
so we're
case.
able to.
Took a competency to pass it already.
Sorry?
I took an evaluation already and passed it. I was deemed competent.
Okay.
The competency hearings on the 11th, I believe,
The 11th of
September.
September.
Mhm.
Okay, so why don't I?
Sorry, the 10th, the 10th.
Why don't I do this then? I'll adjourn the probable cause conference to the 18th. And let's see what you come up with. September 18th, 2025.
Thank you, Your Honor.
Bond continue.
Mr. Veeder, someone will talk to you from the PD's office, okay?
Okay.
Court calls the case, People versus Sean Douglas.
And for Douglas for full relations.
I don't know.
I'll be carrying that really on behalf of Mr. John Douglas, no relation. Mr. Douglas, state your name for the record.
You just can't let anybody have their own thing. You just had to jump,
Mr. Douglas, state your name for the
Good
record.
afternoon, Your Honor. Sean Douglas.
Thank you, sir.
Your Honor, we're asking for an adjournment in this matter.
Of course you are.
Drafting an email to Ms. Douglas. I want to see if Mr. Douglas would be eligible to get into the mental health treatment court. But I need to see if the people are on board with it as well.
Got it. Probable cause conference will be adjourned September 25th, 2025. Next, bond continue.
Thank you, Judge.
Thank you. Court calls the case, People versus Cartier Drains.
Oh, I'm sorry, Your Honor. Lori Yagi, Assistant Public Defender, with and on behalf of Cartier Drains. Come on up to the podium. You have a green sheet. I apologize. Sorry about this, Your Honor. I did write out, here it is. Your Honor, I am asking for an adjournment. Cartier and I have had discussions about this case, but I think we need to talk further about which direction this case is going to go in.
There's two things. One, I'll adjourn this probable cause conference to September 25th, 2025, 9 a.m. And as to his bond, I'll cancel his bench warrant and I'll reinstate his previous bond.
Thank you, Your Honor.
Thank you. Court calls case People versus Keon Ford.
People.
Mr. Ford, will you state your name for the record?
Yeah, Ford.
Thank you. I believe the court should be in receipt of an amended complaint.
And that is,
I am.
Okay.
and that's correct, Your Honor. This time the people would be moving to add that 3 of operating while intoxicated second and dismissing the count 1 of operating while intoxicated third. Once that's done, we'd just be asking us to be remanded back to the appropriate district court for further proceedings.
All right, so you're leaving count 2 in place? All right, so what I will do is count 1 is dismissed. I will indicate that the defendant is pleading not guilty to count 2, maintain his guilty plea to count 2. E-waive reading of that charge. Actually, it's just a change of the notice.
Correct.
All right. So I'll indicate that he's pleading not guilty to counts 2 and 3. I will set this for a pretrial for, is it October 2nd? I'll set it for a pretrial October 2nd, 2025, 9 a.m. before Judge Washington. Bond with all of its conditions will continue. Okay. Thank you, sir.
Thank you, Judge.
Court does call the case of the people versus Jonathan Griffith.
For Douglas for the people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Griffith appears via Zoom.
Mr. Griffith, can you state your name?
Mr. Griffith, we can't hear you.
Jonathan Griffith.
Thank you.
And Your Honor, I am just asking to adjourn this matter for today as I work out
Your
negotiations.
hair looks okay. You're good.
I'm just asking to adjourn this matter today so we can continue negotiations.
Probable cause conference will be adjourned September 30th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Bond will continue.
Thank you, Your Honor.
Court does call the case people versus Taiwan Griggs.
Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Griggs. I did file a Zoom request. Mr. Griggs, can you unmute yourself and say your name for the court?
Taiwan Griggs.
Thank you. You're requesting an adjournment.
I am, Your Honor.
Probable cause conference in this case will be adjourned to September 25th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. Mr. Griggs, please call my office, okay, sir?
Yes, ma'am.
Thank you.
Court does call the case people versus Suzette Hampton.
That's calls for people. Assistant Public Defender Chinazi Kira, Your Honor, on behalf of Ms. Suzette Hampton, who's approaching.
So you want to adjourn it to watch the video? Okay.
All right, Judge, we'll be asking for an adjournment. It looks like there is another piece of discovery that Ms. Hampton would like to review before we move forward.
September 25th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Let's call the case people versus Janae Hardin Noel.
Your Honor, people.
I'm sorry.
This is a PD case, but there's no sign.
Oh, hello. What's your name?
Hello, Janae Hart-Noel.
The PD case.
Assistant Public Defender Jay Bellinger.
I see. What,
Oh.
what, hold on.
I'm a
Thank
PD.
you for stepping up, Mr. Bellinger.
Of course.
What were the rest of you doing?
I was already up.
He just cut you off. Is that what it was? Okay, all right.
Gonna get an adjournment today, okay?
That's always got it. All right, what are we doing on this case?
Your Honor, I would ask for an adjournment on this case so that we can go over discovery with Ms. Hardin Noel.
Okay. Probable cause conference in this case during September 25th, 2025, 9 a.m.
Okay.
Bond will continue.
Okay.
Thank you, ma'am.
Thank you.
Thank you, Your Honor.
Court does call the case People versus Ardashir Hassani. Hold on a minute. You just came up and got in his way? I mean, really? What?
When she
What? I called somebody. What? Somebody's gonna come to the podium. Just have a seat.
Ready to torture fees, assistant public defender on behalf of my client. Please state your name for the record.
My name is Ardashir Hassani.
Thank you, sir.
Thank you, Judge. I have emailed with the prosecutor and spoken to my client. He is requesting a adjournment. He is hopeful that I am able to persuade the prosecutor to allow him into a treatment court.
Probable cause conference, September 30th, 2025, 9 a.m.
Thank you very much, Judge.
Oh,
you wanted me to ask one more thing, Judge? He is an Eastern Michigan student. And he,
oh, yay.
I'm excited about it. He's in class.
What's he studying?
Computer science.
Fine.
He's in class from 9 to approximately 2 o'clock. He was hoping you might consider adding him.
What?
He's in class from 9 to 2 o'clock.
He doesn't go to class.
Hoping you might add him to a 3 p.m. block if you have one that day.
Wow. No.
Fair enough.
All right.
I told him I'd ask.
What I can do. Well, I don't know if we can do this. That day ends at noon.
Oh, okay.
Ends at noon.
Yes.
Okay.
So you have to be here in the morning.
In the morning.
Yeah.
Gotcha.
That work?
What's the first class you have?
I have a networking class and I have an exam that day, Judge.
You have an exam that day?
Yes.
Wow, you're gonna fail.
Truly sorry.
Here's what I'll do. And I'm going to only do this because Ms. Akin really got your way coming to the podium. I'll adjourn this to October 8th.
October 8th.
2025.
Thank you, Your Honor.
Pardon? The 9th. Yes, it would be. Thanks for correcting me out in public. October 9th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you, sir.
Thank you.
Thank you, Judge.
Court calls the case People versus Nisa Hill. Bouncing there.
Oh, yeah, the Assistant Public Defender with, and on behalf of Ms. Hill. Ms. Hill, who's approaching. Ms. Hill, can you say your name for the court?
Nasai Hill.
Antonio.
And Your Honor, I'm requesting an adjournment. This is the first PCC, and we have to talk about the case further.
Probable cause conference, September 25th, 2020.
Thank you, Your Honor.
Bond continued. Thank you. Court calls the case People versus Randy Hockenberry.
And on behalf of people. Assistant Public Defender Chelsea Burchill, and on behalf of Randy Hockenberry, please state your name.
Randy Hockenberry, sir.
Thank you.
Your Honor, we're just asking for a brief adjournment in this case to finish up a plea discussion.
Probable cause conference, September 18th, 2025, 9 a.m. 5 continued.
Thank you, Your Honor. Thank you.
Thank you. Court calls the case of the People versus Dalton Howard.
Lori Yagi, Assistant Public Defender with, and on behalf of Mr. Dalton Howard, who's approaching. Could you say your name for the court?
Don Howard.
Thank you.
And Your Honor, we did just receive media discovery. It must have been sometime before. It was uploaded this morning at like 9:15. So I just need more time to review that.
September 30th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Calvin Johnson.
Cash calls for the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Johnson. Spoken now, Mr. Johnson, will you state your name for the record?
Calvin Johnson.
Thank you. And Your Honor, he has executed a preliminary exam waiver.
Okay. Sir? Yes, sir. You're waiving your right to a preliminary examination? Yes, sir. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them? Yes, sir. You understand you'll not have that hearing, you'll proceed to circuit court for further resolution? Yes, sir. People also waive their right?
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on all three counts.
Your Honor, we acknowledge receipt of the information. My client would waive formal reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all charges. Pretrial will be set for
October 27th at 1:30 with Judge Simpson.
October 27, 2025, 1:30, Judge Hamud. Bond will continue.
Thank you.
Thank you. Court does call the case of the people versus Serrano Johnson. Serrano Johnson.
That goes for the people.
Chelsea.
Sorry, Your Honor, Assistant Public Defender Chelsea Virgil with on behalf of Cyrano Johnson. Did you state your name already?
No, Serrano Johnson. Thank you.
Your Honor, we are asking for an adjournment. There has been an offer in this case that would include my client's participation in sobriety court, so we're asking to adjourn for that purpose.
How much time do you think you're going to need to try to get an answer from them? Have we started that process yet?
I did provide the court with a form. If
I do have
Okay.
it, but
I think it's 3 to 4 weeks. I don't know. If
gotcha. Okay. Then let me do this. Let me probable cause conference to September 30th, 2025, 9 a.m. That's a Tuesday. Okay. Bond will continue. Thank you. How you doing?
I'm doing better, a lot better.
Are you?
I am.
All right. You had a whole lot of folks worried about you. Huh?
Indeed.
All right. Take care.
All right.
Court calls case people versus Stephen Johnston.
Trevor Mayville for the people.
Brian Bowling on behalf of Mr. Johnston, who should be on Zoom, hopefully.
You know, when you said it.
Michael Johnston, Your Honor.
Thank you, sir.
I never know. I never know.
Right.
Your Honor, I'm asking for another adjournment. It's my understanding that this was adjourned previously for him to get into Bear River.
Yeah.
He indicates to me that a bed has become available to him, to his knowledge. He should be able to check himself in there tomorrow, at latest Saturday. So I'm just asking for the court's consideration.
And he's going to be out of communicado for a little bit, and we've got to try to figure that out.
That's correct.
Let me do it this way. Probable cause conference, September 30th, 2025, 9 a.m. Bond continue.
Thank you, Judge.
Thank you, Your Honor.
Thank you.
Thank you, sir. Court calls the case people versus Desmond Jones.
Brian Bowling on behalf of Mr. Jones. State your name for the record.
Desmond Jones.
I'm sorry. Judge, Mr. Cook and I have started some negotiations with respect to this matter, and I think we're close to finalizing something. I'm just asking for an adjournment so we can.
Who's the hang up, Cook? No, never mind.
Usually is me
that
that
answer that.
So we just need to dot the i's across.
Yeah, I took a shot at you. All right. Probable cause conference, September 25th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thanks, sir. Didn't know how to answer that.
I work with him every day. I thought we had a better relationship.
Oh, he didn't get offended by me? Oh, I'll have to get better. That means I get another shot. Nope. Court calls the case, people versus Gerald Manning.
And then on behalf of the people.
Brown, Deputy with, on behalf of Mr. Manning. Mr. Manning, please state your name.
Gerald Manning.
Thank you, sir.
Yes, sir.
Your Honor, today is the date and time set for the probable cause conference. We are respectfully requesting that this matter be set for preliminary examination.
Discovery is complete.
Your Honor, actually, let me rephrase that. Actually, we'll need a couple of weeks because there's information that we think we should have. The prosecution doesn't have it. There's another source from which we will have to get this information. So we'll need 2 weeks.
So you'll need to adjourn it out.
Yes.
Probable cause conference, September 18th, 2025. Will that be enough time to get accomplished?
Absolutely.
What you need? Okay.
Absolutely.
9 a.m. Bond will
Thank you.
Thank you.
Thank you, Your Honor.
Thank you, sir.
Thank you.
Court does call the case of the people versus Matthew Nicolai.
Trevor Maybell for the future.
For the judge, Portia, Eastern Assistant Public Defender on behalf of Nicolai. Mr. Nicolai, please state your name for the record.
Matthew Arthur Nicolai.
Thank you.
Thank you, Judge. I am requesting adjournment on the file. I have reached out to the people to start negotiations trying to resolve this matter. We have not yet resolved this, so I will be requesting an adjournment.
Probable cause conference, September 30th, 2025. 9 a.m. That's Tuesday. Bond will continue.
Thank you very much, Judge. September 30th. Good touch.
Court calls the case people versus Tiffany Cash.
Assistant Public Defender Alexis serves on behalf of Ms. Cash.
Hello,
Hello. What's your name?
Tiffany Cash.
Okay, you're back with us. Okay, good enough.
Thank you for passing the matter, Your Honor. It does sound like she was having a little bit of technical difficulty.
No, I passed it for Miss Cash. Had nothing to do with you.
Well, Ms. Cash thanks you for that.
All right.
Your Honor, we'd respect the request that this be set for a preliminary exam.
Set for a preliminary?
Yes.
All right, discovery is complete.
To my knowledge, Your Honor.
People have their witnesses available the 16th.
Name?
Andrea Desmond.
Well, you sure did the right thing coming in. How much more time do you need?
Me?
Yeah.
Oh, hello, sorry. If I can have to the end of October, please, and thank you.
Ooh, that's a long time. Where do you work at?
I'm gonna stay at home. My income is only once a month.
Can you pay $100 by say September 25th, another 100 by October 25th?
Yes, sir, I can do that.
You pay 100 by September 25th. Balance by October 25th, which would be another 90, okay? If you need more time, come talk to me again, all right?
Thank you, sir, I appreciate it.
Good luck to you. Thank you. You too. Difala Muhafa Al-Jahef. P5T645379. Come on to the voting, the A and B. Your name?
Dave Mahafa.
Where were you yesterday?
To be honest with you, I got the memo that it was supposed to be today. I got mis confused.
Where do you work at?
Ford Motor Company.
How much you making Ford Motor Company?
It's been good.
Well, I know you've had this tickets outstanding though for 5 months.
Yes.
Close to 5 months.
Due to that.
Can you pay one of these today? Which,
Not pay it tomorrow.
you have 232 and 282 plus 213 plus 282 plus a clearance fee. So you have 495 plus a $45 clearance fee. Can you pay all that by tomorrow?
So can I get to the end of the month?
Can you pay the one tomorrow, the 213?
Yes, sir.
Okay. You're to pay that in full by tomorrow, the $213. That's by September 5th, tomorrow, and that is on the expired plate for which you owe 213. I will give you on the no proof, and you have to pay your clearance fee too. You're in suspension. I hope you didn't drive here. You didn't drive over. You pay that one in full by October the 2nd. Can you do that?
How much total?
That one will be 327, including your clearance fee. You can do that or not?
Try.
What are you doing with all your money?
Bills, inflation.
Oh my gosh. Maybe we're gonna put you on some news channels. I'll give you till October 16th on that last one. If you need more time, you let me know. Don't ignore me, okay? I don't like to be ignored. Fair? You honor before the due date. Come in, I'll give you as many extensions as you need. Thank you. Have a good day. People against Hussein Haidar El Hayali, 25F244603. It looks like Attorney McCool. Oh, I forgot to put my picture on here. Counsel, your appearance.
Good morning, Your Honor. Attorney Ron McCool on behalf of Hussein Alaya.
So this is going to be a plea to impeding, right?
That's correct, Your Honor, and I do
Is your
have authority
client
to
going
act.
to slow down a little bit, or is he going to just do this and hire lawyers every time that somehow convince prosecutors? I'm serious. I'm not blaming you, but his record looks somewhere between ugly and bad.
I did talk to him actually through text message after I spoke with the prosecutor and let him know that the record is going to be an issue for him. So I did pass it on to him already, Your Honor.
To the charge of impeding traffic on his behalf, responsible or not responsible?
Responsible, Your Honor.
All right. I'm telling you, if he comes back in front of me, I'm not giving him this, okay? 205, paid by September 11th. Original charge dismissed. Thank you.
Thank you, Your Honor, and I will pass that message. Have a great day.
Thank you. Jeremiah Kennedy Griggs, 25R51414. Come on up here, sir. Your name?
Jeremiah Griggs.
All right, you met with the department rep. You're going to plead to impeding, right?
Yes.
Responsible or not responsible to that charge?
Possible.
Okay, I'm going to set aside the default judgment. Default judgment is set aside. Plea is accepted. You can go down the hall and I think you have a bond. You can deal with them on that, okay? I don't know whose name it is. I don't see that right here in front of me. 225, if it's in your name.
Yeah.
Either way, go down and talk to them, okay? Thank you. Correct. Scott Matthew Reno. 23B143113. But I have seated up here Natalie Brown at the table, my right, your left. Have you talked to your lawyer yet, Ms. Brown? I'm sorry? Have a seat there at the table. I'll be right with you, okay? Sir, your name?
Scott Green.
You're charged with failure to pay $285. So she posted a bond, but I don't see the amount here.
There's a personal bond.
Where you been?
What's that?
Where have you been on this case? This is a 2023 case. Why are we still fooling around with this?
That's gotta be 25. I just got pulled over a couple of days ago.
Well, you got pulled over on a new ticket a couple of days ago. This is from October 6th of 23 that I have.
I got diabetes and it's messing with my memory and.
Do you work, sir?
Yes.
Lisa, can you tell me how much? It says warrant canceled, bond posted, and I don't see anything. in here. Did he post 285?
I don't see a bond. It looks like the warrant was canceled by the police department, but we have not received a bond.
Release on medical. Do you have all this to pay? 285?
I guess I do, yeah. You said I have to pay 285?
You have, I'm asking you if you have the money now to pay this.
If I can make payments, no, I don't.
You've had 2 years to make payments.
Yeah, I
Can't do this, sir.
always took about it, didn't know about
Do you have anything today?
it. Yeah,
What do you have today?
probably about $100 maybe. There's 30, right?
Do you have $100? Yes? I'll tell you what, I'll set you up. You pay 100 right now. You can do that, right?
Yeah,
And then I'll let you pay this. I'll let you set up your own payment plan. How much can you afford to pay weekly or bi-week?
well, I'm getting paid
You just need to tell me how much you can pay.
$100.
You sure? I don't need $100.
50.
When do you get paid next?
The beginning next month. The first of next month.
What kind of payments are they? Is that Social Security?
No, I'm on medical from Baltimore right now, and that's how they're.
Well, I'll let you, can you pay 100 today and $50 bi-weekly beginning on September the 22nd or not?
Sure.
Are you sure?
Yeah.
That's what I'll have you do. You pay 100 today, 50 bi-weekly beginning September 22nd. If you don't have the money, no problem. Call the court. We'll go on Zoom. I'll be glad to give you an extension, okay? Or you can come in. All right? Good luck to you.
Thank you. Getting going.
Where is Rockwood here today, Lisa?
There.
This has to go to Rockwood. This is a 771 case, Ms. Thompson. Where's Ms. Thompson? Okay, so you're gonna go follow this gentleman right here that's walking in. He's gonna take that file to the prosecutor. The review hearing dates in October, and you're gonna see if they'll dismiss it now, okay? Move to dismiss it now. So follow him. Thank you. Natalie Nicole Brown. 25F2589442. Good morning, Mr.
Good morning, Your Honor. Michael A. Carmen, B73824. I'm a defendant.
Ma'am, your name. All right, so just give me 1 second here, if you would, please. Your client pled to disturb the peace. It looks like under HIDA, right?
Yes, sir.
And the agreement was 3 to 6 months. Let me double check that one. Some confusing this. No, to be determined. So have you had a chance to review the report? Whether and are there any material additions, corrections, or deletions? And by the way, is Michaela Harrison here? Michaela Harrison either here in court or on Zoom?
No, not on Zoom.
All right. You reviewed the report, no material additions, corrections, or deletions?
Your Honor, there are actually two. My client is no longer employed at Hampton Manor. As of about 2 weeks ago, she is looking for work at the moment. And just a minor correction, her other child is now age 2 instead of 1. So I went through the recommendations of probation with my client. She knows what is going to be expected of her. Do not anticipate any problems whatsoever. Would ask the court to adopt those recommendations, please.
Ma'am, is there anything that you would like to say here?
Well, not just want to ask me questions.
I'm sorry?
I just want to ask me a question.
Kind of lost your temper here, huh? 10 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. I'm not gonna order all these different programs. I'm gonna order anger management with 4-week follow-up. No contact with Michaela Harrison or Solomon Knighton. No contact with them. You're not to possess firearms. You're not to possess dangerous weapons. Do you understand that, ma'am? You're not to return to 25811 Valley Creek Drive in Flat Rock. Do you understand that, ma'am? Two days on the court work program, 1 day of community service. We're going to schedule you for 2 days on our court work program, which will cost $35 a day for a total of 70. 1 day of community service. I'm going to let you complete that. I'm going to give you all the way until October 31. So again, anger management with 4-week follow-up with firearms, no dangerous weapons. You're not to return to 25811 Valley Creek Drive in Flat Rock. No contact with the victim, Michaela Harrison or Solomon Knighton. Not to possess firearms, not to possess dangerous weapons. 2 days court work, 1 day community service by October 31. Fines are 100. Costs are 75. 75 victims' rights fee, $50 justice assessment. So your fines and costs are 300. Probation fees are 200. And your court work program fees are 70 for a total of 570 plus a screening fee of 60 for 630 plus attorney fees of 40. I believe that's 675. Is that right, Lisa? 364. 600.
I got 670.
670. So you pay 670. We're going to give you a review hearing date. You come back on that date. If you're compliant, the case should be dismissed. Do you understand that? You have 21 days to appeal and 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that? All right. What is the review hearing date? So this should be end of June or early, very, very early July.
I figured out April, so hang on, let me get a different date.
Yeah. Okay. Ma'am, do you have all this to pay?
No.
How much do you have today? I can't hear you. When can you pay this?
I think my son's SSI check on the 1st.
No, my client's asking for a payment plan, and she, for now, when she's unemployed, can she pay $100 monthly?
Yeah, that's $100 monthly, and I'll start that beginning October the 7th. Ma'am, if you don't have the money on any due date, you call the court or go on Zoom or you come talk to me on or before the due date. I'll be glad to give you an extension. Fair enough? All right.
June 25th at 9 o'clock.
June the 25th at 9 a.m. So you're going to get your notice. You're going to go over to probation. They'll go over the order of probation with you, okay? Any questions? All right, I wish you well. Good luck. Thank you.
Thank you, Your Honor.
Thank you. John, good. I'm gonna need this, see if the prosecutor wants to move to dismiss. It was taken under 771, that's the review hearing date. So she's asking for the discharge. Didn't we give a fine to work here? Yeah. Maybe that's the same one. That take that one too.
Okay, yeah.
Oscar Silva. Oscar Allen Silva, 25R514278. Sir, your name?
Oscar Allen Silva.
You're charged with soliciting without a permit. You do have the right to a lawyer. If you want one, I'll give you one. Do you understand that?
What was that, Your Honor?
You're charged with soliciting without a permit. You have the right to an attorney. I'll be happy to provide you with one now at public expense if you want. Would you like a lawyer?
May I ask, like what would be the pros and the cons?
Get a lawyer. We'll give you a lawyer, okay? It's not gonna hurt you, all right? I'm not. Yeah, we'll give you a lawyer, okay? So out in the hallway, he'll set you up with a lawyer. Your lawyer will meet with the prosecutor, and then either way, you're coming back in front of me, okay?
Yes, sir.
Good luck. Matthew James Johnson, file 25F244-454 A and B. Could I have seated up here Anaya, Jessica Lynn Anaya at the table, my right, your left. Sir, your name? All right, good morning. You're charged with driving an unregistered vehicle. If you want a lawyer, I'll give you one. Otherwise, I will arraign you and let you go talk to the prosecutor.
I'll just talk.
Pardon?
I'll talk to you. I don't need a lawyer.
Okay. It is alleged that on August 6th of 25 that you were operating a motor vehicle on Telegraph in Vreeland and Flat Rock at 8:10 in the morning. They think you had an unregistered vehicle, a misdemeanor punishable by up to 100 fines, 90 days jail, costs or all those. I'm just telling you those are maximums. Do you understand that?
Yes.
Did you sign the advice of rights? Did you read it and understand it?
I read it. And I have a couple questions.
Okay. Which ones?
I'm okay. I just stand. I didn't answer my own question.
Okay, you sure?
Yeah.
All right, if you plead guilty, you're giving up all these rights and we're not going to have a trial. Do you understand that?
Yes.
You still wish to waive your right to a lawyer?
Sure.
$100 personal bond. You don't have to post any money. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. You have a second charge here of no proof of insurance of civil infraction. I'm entering a plea of denial on that. You're going to go talk to the prosecutor and then you'll come back in here. Any questions?
No.
You're all set. Good luck. Jessica Lynn Anaya, 25R514-249. Ma'am, your name? You're charged with operating while intoxicated. You have the right to a lawyer. You want a lawyer?
Operating while intoxicated and was the.
I'm sorry. Forgive me. Forgive me. I apologize. Open intoxicants. Open intoxicants. You have the right. You have the right to a lawyer. If you want one, I'll give you one. You want a lawyer? Or do you want me to arraign you and send you to the prosecutor? It's up to you.
It's just a ticket I gotta pay.
It's open intoxicants. It's alleged that on August 5th of 25, that you were at 22855 Huron River Drive in Rockwood and that you had open intoxicants in a motor vehicle. That is a misdemeanor.
Yeah.
Punishable by up to $100 fines, 90 days jail, costs, or all those in 2 points. Do you understand that?
Yes.
And did you sign, read, and understand the advice of rights?
Yes,
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes, sorry.
I'm sorry?
Sorry.
Okay, I just arraigned you. Do you work?
Yes.
Where do you work?
Probably didn't.
All right, I'll give you a lawyer. $100 personal bond. You cannot leave the state without consent or violate a law. You must appear in court as directed. We'll give you a lawyer. Go out in the hallway. You'll meet with the lawyer. The lawyer will meet the prosecutor. Either way, you're coming back in front of me. Okay? Good luck. Patrick, Rock Myron. Okay? I don't know if I pronounced that correctly. If not, I apologize. 25R514258. Your name? Okay. You have an anti-blight charge. They think, let's see, unregistered vehicle in the driveway, damage to front end along with airbag deployment. So anti-blight violation that allegedly occurred August 6th of 24/5 at 21744 Washington Street in the city of Rockwood. That is a misdemeanor punishable by up to 500 fines, 90 days jail, costs, or all those. Understand that? I can't hear you.
Yeah.
And did you sign the advice of rights?
Yeah.
Did you read it and understand it? If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand?
Yes.
You have the right to a lawyer. I'll be happy to provide you with one if you want one at public expense. Would you like one?
No.
I'll enter a not guilty plea for you. Indicate you stand mute. $500 personal bond. You don't have to post any money. I'm going to send you to the prosecutor to talk about this. You cannot leave the state. These are bond conditions without consent of the court or violate a law. You must appear in court as directed. Do you understand all that?
Yes.
All right. So we'll give you a lawyer. I'm sorry. We'll send this into the prosecutor, the Rockwood prosecutor. You'll talk to him and then you'll come back in front of me. Okay. Any questions? Good luck. Sean Carpenter, Sean Raymond Carpenter, 25F244645. Could I also have Gordon Alfred seated at the table, my right, your left, and John Boland? Your name, sir?
Sean.
All right, you're charged with driver license expired. You want a lawyer?
No.
It is alleged that you did operate a motor vehicle with an expired license on Eastern River Drive near Seneca and Flat Rock, August 18 to 25 at 10:06 in the morning. That is a misdemeanor punishable, up to 100 fines. 90 days jail, costs for all those, and 2 points would be added to your record. Do you understand that?
Yes.
Did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights. There will not be a hearing or a trial. Do you understand?
Yes.
You have the right to a lawyer. You still wish to waive your right to a lawyer. I'll enter an act guilty plea, indicate you stand mute, $500 personal bond. I'm going to send you to the prosecutor. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. You'll go talk to him, and then you'll come back in front of me today, okay? Good luck. Gordon Banks Alfred, 254W835-274A. This is a probation violation. Your name, sir? You are charged with a violation of probation. I sent you September 18 to 24. I have a violation here that alleges that you failed to attend your scheduled probation visit on August 18 to 25. That is count one. You understand the charge? Count two, that you failed to pay your fines and costs as ordered. Do you understand the charge? Count three, that you failed to submit the monthly testing as ordered. On July 15th, that's count three, and again on August 12th, that's count four. Do you understand that? You plead guilty, or if you're found guilty, these would be four different technical violations. Your probation could be revoked. You could be incarcerated for 93 days. Do you understand that? And did you sign, read, and understand the advice of rights? If you plead guilty, you'll be giving up all those rights, and there will not be a hearing. Do you understand that? I gotta have you speak up. She's got to pick up what you're saying.
Sure.
All right. You have the right to a lawyer. I'll be happy to give you one at public expense if you want. You want a lawyer. I'm gonna enter an not guilty plea for you. We're gonna give you a lawyer today. You'll go speak with the lawyer, and then you will come back in front of me. Any questions? Okay. Good luck. We'll see you in a few minutes. People against John Boland, rather, 25F4244668, A and B, your name? John Boland. All right, Mr. Boland, you're charged with driving on a suspended and speeding. You have the right to a lawyer if you want. You want a lawyer?
Yes.
Okay. Go out in the hallway. We'll give you a lawyer, and you'll meet with the lawyer. The lawyer will meet with the prosecutor, and then we'll see you back in here. Okay?
Thank you.
You're welcome. Shoemaker. Randy Lee Shoemaker, 24B724247. Name?
Your Honor.
You're charged with failure to provide proof of completing 120 hours of community service by August 1. That is the charge. This is the moving violation causing death. If you plead guilty, you could be given 5 days in jail as a result of this. Do you understand that?
Yes.
And did you sign an advice of rights today?
Yes.
Did you read it?
Yes.
Understand it?
Yes.
If you're guilty, you will be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
You have the right to a lawyer. Be happy to provide you with one at public expense if you want one. Would you like a lawyer?
Yes, Your Honor.
Okay. I'm not guilty plea. We'll set you up with a lawyer. Either way, you'll come back in front of me, okay?
Thank you.
Welcome.
Oh, that's
Yes, sir, and we'll set you up. And we'll talk to the probation officer or whatnot. People against. Reimer Freight Lines, 25T646125.
Good morning, Your Honor, to you and your staff, Attorney Maxwell Dubin, plea number 86012. On behalf of Liner Freight Lines, we're respectfully requesting a waiver of their appearance here today.
All right, you don't need to ask for that. That's fine. You're going to plead to overweight. There's agreed upon fines and costs of $2,000. True?
That is correct, Your Honor. I do have authority to plead responsible on my client's behalf.
To that charge of overweight on their behalf, responsible or not responsible?
Responsible, Your Honor.
Plea is accepted. Fines cost $2,000, paid by October the 3rd. October the 3rd, okay?
October the 3rd. Thank you. Great to see you and your staff, Your Honor. I hope you guys have a wonderful rest of your day.
Have a good day, Mr. Dubin. Thank you.
Thank you.
Lipchick, Austin Tyler Lipchick, 25R514271. Could I have seated up here, Al Namer? Mansour Al Namer? Your name, sir?
Austin Tyler Lipchick.
Mr. Lipchick, what do you do for a living?
I just started my own business. I currently got through all property managers.
You're looking good. The reason I asked, you show up with some respect. You got a tie in. Nice to see. Good to see.
I appreciate that.
You're going to plead impeding, right?
Yes, sir.
Responsible or not responsible to that?
Responsible.
All right, please accept it. Original charge dismissed to speeding. 160 is your total. Can you pay that?
Yes, sir.
You're all set. Have a good day.
Thank you, Your Honor.
Thank you. Mansour Hamid M. Rajay El Namer, 25R514256. Your name, sir? Listen, you got to be careful. You can't operate a vehicle in text, okay? You're going to plead to impeding, right?
Yeah.
Responsible or not responsible?
Responsible.
Please don't do that. 195, original charge dismissed. You're all set. Good luck. Thank you. Mr. Granati, we ready on Godfrey? People against Richard J. Godfrey. 25F244515. Good morning, Mr. Granata. How are you?
Peter Bernardo, P7843 with, my name is Cedric Simpson.
How you doing, Mr. Godfrey? Your name?
Richard Godfrey.
All right, so your client pled guilty to disorderly public intox.
Yes, sir.
The plea was to be taken under section 771.1 for 6 months. Have you had a chance to review the report with him?
Yes, Your Honor. Mr. Godfrey and I reviewed the pre-sentence report, and there are a few things that we would ask the court to consider. First, Mr. Godfrey has already joined up or started participating in AA. He will be attending weekly meetings, from here on out. He has been, he is abstaining from alcohol since our initial hearing about a month ago. And he is on his way to sobriety. He's also consulted with he's gone on the internet and found some resources there to help him with his journey to sobriety. And I believe that he's well on his way there. We would ask the court to, in consideration of the fact that Mr. Godfrey has no past criminal history other than a OWI back in 2018, that the court will, and because of his indigency, he's not currently working. He's retired. He's on a fixed Social Security. That Social Security benefit has been reduced recently by a couple $100 a month. And we would ask the court to, at all consideration, to either waive or reduce the amount of fines and costs as a result of today's sentencing. But we would ask the court also to not follow the recommendation as far as community service. We believe that it's just not necessary as far as punishment for the infraction. And we would also ask the court to consider not following the recommendation as far as an intensive outpatient drug treatment program.
Is there anything you would like to say, sir?
I'm sorry, I can't hear you.
I'm sorry. Is there anything you would like to say?
follow up with the AA. Like I was recommending 3 times a week. I also found a website that's has been very helpful.
How do I know you haven't been drinking?
Pardon?
How do I know that you haven't been drinking?
I have not had a drink since I've been here.
Okay, but how do I know that? Because I mean, I never had you test.
I swear to God. I've been going through withdrawals. I've had nausea, vomiting. Tremors are gone. I can barely walk. It's getting better. That website I found that said that my legs will get better again. Okay, diarrhea.
Yeah, we don't need to get that specific, but
I'm sorry to bring all that up,
well,
but
that's fine. When are you eligible for Medicare? When do you turn 65?
October 1st.
Have you signed up for Medicare?
Yes, I have Medicaid right now, which I just
Okay.
a couple of months ago.
How about if he does outpatient treatment? I can live with that in AA twice a week. Any real strong objection to that? Look, I just don't want you to die. You didn't hurt anybody. You fell over. You're drinking too much. That's the only thing. I can cut down the testing for you. They recommend twice weekly, I believe. Yeah, weekly testing. I think that'll make you go broke, to be honest with you. I'm not going to do that, but I want to make sure you're not drinking.
I have not been, and I don't plan. This has been a wake-up call.
Well, that's good. I mean, it really.
Once ago, I went 40 days without a drink, and then, of course, I started drinking again.
Well, don't.
I fell down, and then got the citation. I couldn't get back up. If I lay down on the floor here, I couldn't get back up. My knees were shot.
6 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no
not the drugs in 4 years.
Right. No alcohol, no illegal drugs, no marijuana, no kratom, no poppy seeds, no CBD oils. So kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items with those substances will be deemed a violation. I want to have you submit to chemical testing, PBTs and ETGs bi-weekly for 2 months. If you're clean, I'll make it monthly. Okay?
Thank you, Judge.
So I'm not going to make you do this weekly. I don't want you to go broke. That doesn't mean you have a license to drink. You can't drink. 2 times I want you going to AA per each week, plus outpatient substance abuse treatment.
Where would that be at?
They're gonna explain to you. Probation will set you up. I'm gonna order one
AA 3 times a week.
I want you. AA is great. It's a support, but you still need. Listen to me, sir. AA is great. It's a support group, though. It's not treatment. I'm not going to order intensive outpatient, which would be 3-4 times a week. I'm going to order outpatient, which would be once a week. You do that. 1 day community service. I'm going to order you to complete that by October the 31. I'll go light on the fines for you. 50 fines, 50 costs, 75 victim's rights fee, $50 justice assessment. 2 1/4 probation fees are 120 for a total of 345 plus the screening fee. So your total here is 405. 405. You may be eligible for early discharge. Okay.
Yep.
So if you do everything in 3 months, I don't know that you can get through outpatient, but if you get in there right now, you can. You can apply for early discharge and I'll grant it as long as there's been no violation. Okay.
Do outpatient for 3 months.
You're going to do outpatient as long as the treatment specialist thinks you should be an outpatient.
Okay.
This is intended to help you. This is not a penalty. Outpatient's not a penalty. AA is not a penalty. Do you have proof that you've been going to AA? Have you had an AA form signed every time?
No, he hasn't actually attended his first meeting. He's basically found.
You attended. I told you on August 7th to go 3 times a week. Maybe I misunderstood. Why aren't you going?
I've been barely able to walk. I have 3 places, 2 in Rockwood.
John, give him another AA form. Listen to me. If you don't go to AA, you're gonna force me to do something that I don't want to do.
I'm going.
Did you hear what I said? You've ignored that order for a month. Sir,
Yes, sir.
did you hear what I said?
No.
You've ignored my order for a month. You can't ignore court orders or bad things happen.
I'm sorry.
Can you pay any of this today?
Yes, Your Honor, all of it.
So he's got some money.
Right.
Okay, you pay that today, you'll meet with probation. Start going AA. Every time you go, you have to have the form signed. Every time you come and meet with probation, you have to bring that with you. If you don't have it, or the dog eats it, or it flies out the window, I'm gonna assume you did not go. Do we understand one another? All right. You got to get your life in order here, okay? I just don't want anything to happen to you. Do what I'm telling you to do, and I think we can minimize it. Good luck.
Thank you, Judge.
Thank you. People against.
Do you want a
Dylan
review
Bemis. Oh, wait a minute. Wait. I'm sorry. I need a review hearing date on this. My apologies.
December, you believe summer?
We're gonna give me a date and what do you think, Lisa?
February 20.
The court's, I'm sorry, the clerk's office docket this morning and saw that you been making payments, going to continue to make payments, right?
Yes, sir.
All right.
Getting on track. So,
Okay, let's stay on track. Let's get this done.
yes, sir. I agree.
2016.
I know.
Let's get it done.
We will.
You want us off your back, right?
Yes, sir.
And I want to make the victim whole. So
Right.
let's get it taken care
I will
of.
do.
Okay. All right. Do we need to set another review or are we good for now?
If need be, I can always reach out. and
Okay,
request.
no more coming to see me. Let's just keep this regular payments for this restitution.
I
Okay,
will.
all right, good job.
Thank you.
Gentlemen,
Sorry.
how are you? Oh, we ready? All right, this is case number 25 CR 42376, the state of Ohio versus Brandon Dates. Mr. Dates is before the court with his counsel, Mr. Kirby, Ms. Nicholson, on behalf of the state of Ohio. This is our final pretrial before our scheduled jury trial date of 9/22/25. State have an offer?
Your Honor, the offer was to plead to the indictment, which is a one count of harassment with a bodily substance, with a agreed 6 months consecutive, the minimum consecutive sentence, which is our standard offer in these types of cases.
Mr. Kirby?
Your Honor, I reviewed that offer with my client, his options of accepting that offer or entering a plea of no contest. At this time, he'd like to reject that offer, keep the trial dates.
Okay, so we're set to begin the morning of September the 22nd, which is a couple weeks away. You'll deal with the civilian clothing issue, check with LT on that.
Yes.
And make sure that we get Mr. Dates into civilian clothing for the trial. I don't think there's anything else we need to do. Anything else, Ms. Nicholson?
I don't believe so.
Mr. Kirby?
No, Your Honor.
All right, I'll see you all back here in a couple weeks.
At 9 o'clock.
If he gets done before them, I'm not gonna have any problem with him meeting or talking to the prosecutor about the dismissal early.
Thank you, Judge.
Thank you very much. Dylan Bemis. People against Dylan Ray Bemis, 25R 514-250. Morning, Mr. Hall.
Good morning, Your Honor.
I have not seen you in a long time. How are you?
Your Honor, I'm thinking the same thing. It's a pleasure being in front of you today. I'm doing well.
Good.
Mike Vincent's doing well as well. He told me to say hi.
Good. Best to him.
Absolutely. He's still doing his boxing workout every other day.
Good for him. Good for him.
Judge Joseph Holbring Ford, on behalf of Mr. Bemis, who now stands to my left. I do have an executed and place of rights that I'd like to provide to the court.
Okay.
Mr. Bemis has had sufficient opportunity to review those rights. He has no question to the court. At this time, is prepared for arraignment.
Mr. Bemis, your name?
Dylan Ray Bemis.
All right. Do you want me to formally arraign or does he stand mute?
Your Honor, we'd wait formal reading stand mute at this time.
I'm entering not guilty plea. He doesn't have any priors, does he?
Your Honor, this is his first ever criminal contact with police. He had no priors of any kind. He has been sober since date of offense. He's gainfully employed, he lives locally, and he would test negative for all substances today.
What was the,
We had an intoxilizer alleging a 0.128 and a 0.131.
give me a bond sheet, please, Tabitha. $1,000 personal bond. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. No alcohol, no marijuana, no illegal controlled substances. I'm entering a not guilty plea. I'm signing your discovery order, Mr. Hall.
Thank you, Judge. I got the opportunity to speak with Mr. Pellin. He's not here in 4 weeks, which would be a normal docket date for him. So we are sort of in an extraordinary manner, asking for the docket day after that for Rockwood, which I believe is 6 weeks from today.
Okay. Lisa, what date do we have?
October 16th at 8:30.
So October 16th at 8:30 will be the next pretrial. And we'll go from there. Anything else, Mr. Hall?
Nothing further at all. Thank you so much, Your Honor. It's great to see you.
You too. Have a great day. Thank you. Thank you. People against Thompson, take care. Tricia Ray Thompson. Good morning, ma'am. 250-514-1088. Can I have Matthew Johnson and Sean Carpenter seated at the table up here? My right, your left. Ma'am, your name? All right, well, I figured we'd save you some time here. Your review is set for October 29th. I sentenced you. What date did I sentence her? I didn't date it for some reason. Looks like on May 15th, I think. Raise your right hand. You solemnly swear affirm, under penalties of perjury, that the testimony you'll give in these proceedings will be the whole truth self you got.
Yes.
All right. Since you were in front of me, have you been arrested? Any new charges?
Sir.
Any cases pending?
No, sir.
No contact with the police?
No, sir.
Congratulations to you. I'm going to go ahead and dismiss your case on motion of the prosecutor. We'll send you the discharge. You're off probation. I wish you well. Good luck. Thanks. Matthew James Johnson, 25F244454 A and B. How you doing, sir? Your name? You're going to plead the expired plate. They're going to dismiss the unregistered vehicle. You're also going to plead to no insurance. True?
Yes.
To the charge expired plate, responsible or not responsible?
Responsible.
To the charge of no proof of insurance, responsible or not responsible?
Responsible.
I'll accept those pleas. I will dismiss the unregistered vehicle misdemeanor. You have a valid registration.
I have the title. I am working on getting the registration.
So you don't have valid registration. You don't have valid insurance either, right?
No.
You got to get that. I mean, you get in an accident, it's your fault without insurance, they'll be chasing you around till you're an old man. 185 on the no proof, 130, 125 on the expired plate. Do you have all that to pay?
How much is that total?
310.
Yes, I do.
Okay, you're all set, or 320 rather, 320 rather. No, I was right the first time, 310.
One question for you. Where do I go for that?
You go right down the end of the hall, go out those doors all the way down the hall to your right to the cashier, okay?
Okay.
Best of luck. Get your stuff taken care of though.
I'm doing my best.
All right.
Thank you.
Sean Raymond Carpenter, 25F244645. Jacob Lesnow, have a seat at the table, my right, your left. Sir, your name? You're going to plead the 5 over and they're going to dismiss the expired license, true?
Yes, sir.
You were speeding? That's why you were pulled over? You were speeding? Pardon?
It does find your license.
I mean, it saves you a point. All right, that's what you want to do? To the charge of 5 over, responsible or not responsible? Please accept it. Expired license dismissed. 150 is your total, okay? You can pay that now?
Yes.
Go ahead down the hall. You're all set. Good luck. Jacob Christopher Lesnow, 24F242298. Your name?
Jacob Christopher Olsen.
Your charge appeared to submit to weekly testing is ordered on August 18th of 25 via DNA. That is the charge. You have 2 prior technical violations. This would be the 3rd. You could get 15 days if you're convicted here or if you plead guilty here. Do you understand that?
Yes, sir.
Did you sign an advice of rights and read it and understand it?
Yes, sir.
You plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
You have the right to a lawyer. If you want one, I'll give you one. Do you want a lawyer?
No.
You sure? I'm just asking.
Yes, sir.
All right, to the charge that you failed to submit the weekly testing as ordered on August 18 of 25, how do you plead? Paul and Emily, please. Did you fail to submit the testing on that day?
Yes, sir.
Anybody in this world force you to plead guilty?
No.
All right, I'm gonna accept your guilty plea. I find it to be an accurate plea made voluntarily and understandingly. Why didn't you?
The 18th, was a Monday. I didn't have my phone during the morning on 18th. I left it, so Sunday night, I left it in my girlfriend's car. It was an 8 call in the morning. Went to work. Right when I got home, she was at my apartment. I texted and emailed Miss Tessino like right away the situation. And I woke up the very next morning because I knew she was going to email me back. Said I could go test. I would have discussed like the very next morning. So I was unable to call in the morning and then I had to work. That's all. And then I tested the very next morning.
Why didn't you call on your girlfriend's phone?
I didn't have my girlfriend's phone. She was at work. I left my phone in her car. She goes to work at 6:30, 6:45. I work at 1 in the afternoon.
All right, have a seat. I'll be right with you. I'm accepting your plea though. Jacob Timothy Stump, 25F11627.
Good morning, Your Honor. To the record, House Counsel, Attorney Mike Baldwin, D at 5417 on behalf of Mr. Stump. Third, can you just please state the legal name to the record?
Is Zachary Stump here?
No, but the mother is the biological mother. And I say that for 2 reasons. First of all, Judge, today's date time set for sentencing. We acknowledge receipt of pre-sentence investigation report. Under residency, the victim lives in Flat Rock. The defendant lives in Westland per the bond conditions. Therefore, this report needs to properly reflect that my client does not reside in Flat Rock. There are no additional deletions, corrections, errors. We're asking, it's stated 12 months probation, but this is the delayed sentence to 3 to 6 months. We're asking the court to adopt the recommendation as to provisions 1 through 5, asking for no assaultive contact with the victim, a minor child. The mother is here. Moreover, the mother has been intricately involved in the entire process from start to finish. This was a family matter. Words were said. The child jumped out the window, which is not uncommon in his bedroom. He went to the neighbor's house.
How old is Zachary?
But he's 17 in October.
Why were you going out of control on him?
So
Because I know he didn't clean the bathroom. I read the report.
yes, sir.
Okay, I get it. Well,
Am I allowed to explain myself?
yeah,
It's
absolutely.
sibling rivalry, Judge, and my client is the older sibling and knew or should know better to make sure that he's not using disparaging words to frighten his younger brother.
What do you want to say?
Just in that morning, I walked in on his bedroom, talking to him, very nice, like 4 times, because he had asked me for the last week, or told me the last week he was gonna clean. And I was just asking him, are you gonna clean or not? And then he was like screaming at me, like, telling me this, that, all these other mean words. And finally, I just had snapped. I just said, the words I had said. And there's a thing on the report that.
Did you say, were you banging on the door and stating you were going to kill him and beat his ass?
Said I was going to kill him.
Did you say you were going to beat his ass?
Yeah, sure.
All right.
It was just as a brotherly thing, like, we were arguing as brothers. It was.
I got a brother. We didn't threaten to beat up each other. Come on.
We never.
Brothers are going to have disagreements. Go ahead. I'm listening.
It was just us arguing. It was, like we weren't. I have 4 other brothers. We argued like that before. It's never been.
Well, maybe you ought to stop.
Yes, I'm going to start going to therapy and taking care of my anger and
I did snap out, but there was no excuse for it. You know, I'm doing well on my own. Like, I work out every day. I have my own company. I was doing great before working with my dad. Like, I've never done anything bad. Like, I don't have the criminal history. I'm not really having anger issues. I just really needed to get out of there. You know what I'm saying? And I don't argue with anybody. I'm well off, I guess, you know.
Lisa, give me a review hearing date, 6 months, 6 months probation. You cannot leave the state without the consent of the court. You cannot violate any law. I'll take it under section 771.1 as set forth in the stipped form. Anger management, attend that with 4-week follow-up. No contact with Zachary Stump.
Yes,
You
sir.
cannot write, phone, see, text, email, or communicate with Mr. Zachary Stump or have anybody else do any of those things for you or on your behalf. You're not to possess firearms. You have any firearms, dangerous weapons?
No, sir.
All right, you're not to possess any. 1-day court work program, there's a $35 a day charge for that. So you have to pay $35. 1 day of community service, 8 hours. You can do that at any nonprofit organization. Your total 8 hours community service must be completed by October 31. Fines 100, costs 100, 75 victims' rights fee, $50 justice assessment. Screening fees 60 for 385. Probation fees are 120 for 505. You have court work program fees of 35 plus attorney fees of 40. Your total's 580. You pay that, you stay out of trouble.
Yes, sir.
You obtain and maintain employment. Again, no contact, no firearms, no dangerous weapons, anger management with 4-week follow-up.
Your Honor, I have one consideration. We do have the biological mother here. We're seeking no assaultive contact, especially as we're rounding into the holiday season. This is becoming.
I can't speak, she can't speak for Zach. He's 17. I want to hear from him.
Yes, Judge. So if we schedule.
Yeah, I don't have a problem.
A Zoom hearing and.
Yeah. He can file a handwritten motion, wish to have contact with my brother. And probation will notify, and if you have any problem with this,
yes,
you tell them, I want them to notify your brother. He can appear in person or by Zoom. We'll schedule it. And I'll be happy to modify the order so long as he agrees.
Yes, Judge.
I know he's 17, but yeah, I still.
You could be emancipated at that age. So.
Okay, Lisa, do you have a review date?
26th at 9 o'clock,
I'm sorry, you cut out. What 26th of what month?
February.
2/26/26 at 9 o'clock will be your review hearing date, okay?
All right, thank you.
Do you understand everything?
Yes, sir.
Can he pay all of this today, counsel?
I get paid $200.
All right. So you pay 200 now. When can you pay the other 380?
Is there a way I could do like 100 a month or like 200 a month, one of the two?
I'm going to ask for 100 a month, Judge. He's self-employed.
I work with my father on the side and.
Yeah, I'll do $100 monthly, but all due by December 20th.
And he looks good in a suit and tie. I am very appreciative.
Well, that's nice to see somebody showing a little bit of respect, but that's just me. Have a good day. Good luck to you. Thank you.
Thank you, Your Honor. Judge, if it please the court, you're all set. Because he needs to go to probation.
Yes.
Okay.
And then go down the hall and pay the 200. Good luck to you. Jacob Lesnow. Jacob Christopher Lesnow. I'm going to go on to this one. I have Ms. Tessino here. Your name? Sir, your name?
Jacob Christopher.
He's telling me that he missed the test because he left his phone at his girlfriend's and he didn't have a phone to call and then he realized it and he got a hold of you that day on the 18th. Is that true? And he tested the 19th?
He did. My kind of reasoning for the show cause, we've had a bumpy couple months with him that, I don't know, if for me, I probably would have just whipped DNA.
What's going on with you?
No, I should have. Honestly, for now on, I mean, this is not going to happen again, but for now on, if I can't call, I'm just going to go test right away. But the other bump the road, just being knowing that help for work, which I'm not even going to.
Yeah, remind me of that. What happened on that one?
He had emailed me.
Yeah.
I didn't get back to him. He left anyway. His car.
Yeah.
day.
You gotta be more attentive here, young man.
Yes, sir. I completely understand. I applied right away as soon as I could. I tested the very next morning. I couldn't even call in the morning. I honestly did the best I could. I was not trying to make anything difficult. I emailed her right when I could. And I went the very next morning.
What do you think?
Like I said, it's hard, I would like to believe him, but I just feel we've had a lot of weird situations.
Yeah, I remember this now. I think you're trying to cheat.
No, you're on. I really am not.
You didn't do what you were supposed to do before. You don't get to leave the state without permission.
Yes, yeah.
It costs us 75, 1 day court work and pay 35 for that, total 110. You're getting yourself into some murky waters here. You have the 110?
Can I do? Yeah,
just pay by September 18th. Can you do that?
Yeah.
Okay?
Yeah.
She'll set you up on the day on the court work program today. Best of luck to you. Thank you. People against Ron Sheena, 25R514-107A. Good morning, Mr. Sheena. Your name?
Ron Sheena.
All right. Raise your right hand, please. You solemnly swear affirm on the penalties of perjury, the testimony you've given these proceedings will be the whole true self you got.
Yes, I do.
You were in here May 15th. The charge was furnishing alcohol to a minor. It was taken under 771.1 for 6 months. You've applied for early discharge. The file was sent to the prosecutor. It says you're compliant. Since you were in court on May 15th, have you been arrested for any reason?
No.
Any new charges?
No.
Any contact with the police?
None.
Prosecutor moves to dismiss. Congratulations to you. Case is dismissed. And we will send you the discharge, order of probation, dismissing the case and
Thank you very much.
discharging you. Good luck to you. Thank you.
Thank
People
you.
against Urso. Anthony Jordan Urso. Call him Mr. Baldwin. 25R 252-558-OM. Stay right there if you would, please, until your lawyer comes in, okay?
Yeah, Judge needs him, yeah. I don't think so. No, it's fine.
Good morning. I called Anthony Urso. Sir, your name?
Attorney Mike Baldwin, House Counsel, P 65417, on behalf of Mr. Oso.
Sir, your name?
Anthony Urso, Your Honor.
All right, sir.
Judge, today is the date and time set for sentencing. Just bear with me here while I pull up my report. We have gone over the pre-sentence investigation report. Judge, we announced that there are no deletions, corrections, errors, or omissions in this report, Judge. We're asking the court to adopt the recommendation. I believe this was taken under the deferral statute related to A and B. And he is gainfully employed as a laborer. He has no marked past criminal history. He's in good health. He's not on meds. So I'm asking the court to allow him an opportunity to show the court throughout the probationary period that he can satisfy the terms and conditions and be afforded the opportunity for discussion.
Sure, I'm Michael Annisberger here. Michael Annisberger, either here or
Here.
come on up here, sir. Yeah. John, go help him, will you, please?
All right.
You want us to stay here or sit down?
No, you're good. What's your name, sir?
Michael Thomas Sandensberger.
I'm glad you came. I'm gonna come back and ask you if you have anything to say here momentarily. Is there anything else that you would like to say, Mr. Ball?
Yes, this was a bond condition for my client not to have contact with this person. And I have reason to believe that my client would like an opportunity to apologize on the record in open court when he did not want to violate his bond condition by having contact with him. Is that correct?
Yes, yeah.
I don't have a problem.
Go ahead and apologize.
I would like to apologize to you, Michael, for what I did instead of the day.
What did you do?
I slapped you in the face. It wasn't right of me to do that. And I wasn't thinking you clearly. I hope you forgive me.
Would you like to say anything, Mr. Ansberger?
Yeah, I think he's somewhat a little bit dangerous. There was absolutely no reason for this. And I probably would have let it go, but after he so-called slapped me, which was more like a punch because I've got black and blue marked pictures that I can show you. And also I was watched for a possible brain bleed because I'm on blood thinners, okay? But he just took off, he jumped in the car, rolled the window up, threw my bag, I carried my stuff in, out and took off. No, he would have come around, said, hey, I'm sorry, would have been a different story. This man has a pistol, okay? Legally, whatever. I just think he's a little bit dangerous. And flies off the handle. This is not the first time. He trashed my office once. He didn't like the work or what. I'm giving him, his two other brothers, jobs and all that. We have stuff still missing. Can't say it was stolen, but it's gone when I had it, when he was working. That's about it.
Anything else?
No, that's it. I'm a pretty easy guy to deal with. I was a probation officer for 20 years myself.
Where?
Baltimore.
Judge McGann and Brzezinski?
Brzezinski.
Very good men. Very good, very, very, very good men. Very good judges.
Pretty well known in different facets of the legal system. So
Well, I'm glad you came. Is there anything else you want to say, Mr. Russo?
Ma'am. Your Honor, we're asking for IDA. IDA requires that the individual make an admission and that.
The prosecutor already agreed, right?
I agree. The point that I'm trying to make is my client has some work to do to earn this IDA. And that is what this court orders him to do. And I trust anger management or a component thereof will be a part of that IDA process to further assist my client as a younger individual in how to handle his matters when he's socially interacting with other people.
I don't know how to put this delicately. I don't know if I'm capable sometimes of putting things delicately. He just struck a man in a wheelchair. That's so demeaning. So demeaning. It doesn't take much of a man to do that. I say it sometimes in here, and I don't care who thinks what about it. It would be an interesting scenario if anybody who's ever charged with domestic violence or aggravated assault or assault and battery went and picked on one of the MMA guys or somebody who's 6'4", 262 pounds that plays linebacker for a professional football team. And this just this agitates me because you took advantage of the situation And if he was 6'4", 262 pounds, I doubt you would have slapped him, especially if he wasn't in a wheelchair. So you better take a good long look at where you're going. I appreciate the fact that you don't have a criminal history. I believe what he told me. He's expressed concerns, and I share those concerns. 12 months probation. I'll take it under HIDA. You cannot leave the state without the consent of the court or violate a law. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. I'm going to order that you attend an anger management program with 8-week follow-up. You're to attend that, complete that. You're not to enter 32823 4th Street in Rockwood. You're not to have any contact with Michael Lansberger. Cannot write, phone, see, text, email, or communicate with him, or have anybody else do any of those things for you or on your behalf. You're not to possess any firearms. You're not to possess dangerous weapons. If you have any firearms, he just said you did, you are to surrender them immediately and go talk to the prosecutor in Rockwood. He's here still, and the lieutenant, and tell them when you're going to surrender their firearms and how you're going to go about it. Do you understand that?
I already surrendered, when I was given the first court date.
Okay, where are they now?
They're in either Rockwood or Gibraltar.
Okay. All right. No firearms, no dangerous weapons, no contact. Don't go back to 32823 4th in Rockwood. Anger management with 8-week follow-up, 3 days court work. There's a $35 a day charge for that for a total of $105. Fines are $100, costs are $125, $75 victim's rights fee, $50 justice assessment, $350. Screening fees $60 for $410. You have probation fees are $240 for $650, attorney fees of $40 for $690, plus you have court work program fees of $105. Your total fines and costs are $795. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. I'm going to give you a review hearing date. I expect you to stay on the straight and narrow. When I read he was in a wheelchair, I thought that was not good. It's not that I condone in any way assaults of any kind, but you start assaulting people in wheelchairs, it tells me a little bit. You got something going on up there we got to fix. Do we understand one another?
Yes, Your Honor.
I'll take a review hearing date, Lisa, please.
August 27th at 9 o'clock.
August the 27th, 26 at 9 a.m. Do you have all this money to pay or do you need time?
I have a honor today.
There's no restitution, right, sir? Everything was covered?
Yes.
$200 now, and you make $500 a week. I'll let you pay $75 bi-weekly, and I'll start that beginning on September the 19th. If you need more time, no problem. You call the court, we'll go on Zoom on or before due date, or you can walk in here, and I'll be glad to talk to you on or before due date and give you an extension. Just don't ignore me. You're going to go down the hall. You're going to get your paper notice. You're going to go over to probation after you pay your $200 too. You're going to go over to probation, and then you are going to be instructed. Any questions?
No.
Thank you. Good luck. People against. Thank you, Mr. Ansberger.
Thank you.
I really had a lot of respect for those two judges. Joshua Edward. In fact, my father was good friends with both of them. Joshua Edward Schaefer. 218-235-3218. Where's Mr. Schaefer at? Okay.
While he's extending the courtesy to that gentleman, Judge, I'm going to place my name on the record as something like Baldwin, one count for Mr. Schaefer.
Is he just walking in today?
No, Judge, he's
Did you?
no, he was on time. He's kind of.
Yeah, okay, that's fair. I don't have a stip form here though. Did you meet with the prosecutor on this?
Yes, sir. We are. There should be a stipulated plea form and signed advice.
Did you see one, Lisa? I mean, Tabitha?
I don't think I've seen one for.
I don't think so.
We may not have gotten to that juncture, a thousand pardons. Where, I thought he wrote it up, he did.
Couple of weeks ago, huh?
Judge may have the file, I'll take care of it and make sure that everything is neat and tidy and ready to go. I'm just had to see, and that might have been my mistake. I'm
Okay.
mistakes.
That's okay, no problem. Myron, I am so sorry. Patrick Myron, Kim, okay? 25R514258. I'm sorry. Murder in your name there, sir. How you doing? Your name? Okay, so listen. Get the car out of there.
Okay.
Yeah, I will adjourn at 4 weeks. Lisa, give me a date like 4 weeks out.
Not here in 4 weeks, so I can go 2 or 6.
I'll go 6, that's fine.
Okay, October 16th at 8:30.
October 16th at 8:30. Get the car out of there earlier, okay? If you can, please, will you do that? Then they'll dismiss, I'm sure. It'll be good luck. Kelly Ann Ferguson, 19R511 211 20R 511 787. Ms. Ferguson. Good morning. You're back.
Yes.
Did I give you a lawyer before?
I said I'm a lawyer, so I'm here on the lawyer.
Okay, slow down. Keep your voice up. I arraigned you on this probation violation on August 28th, and I see I adjourned it until September 4th this morning. And then on the other one, I just entered a not guilty plea, and I adjourned this one until September the 4th at 9. Did I give you a lawyer before?
Yes,
Who was your lawyer?
just walk out.
Mr. Baldwin?
Yeah.
Have you talked to him today? Okay, I'm sorry. I wouldn't have called it if I'd have known that. Have a seat right there behind you at the table there. John Joseph Boland, file number 25F244668,
I think that one is,
A and B. Who's this, Mr. Baldwin's again?
and then these two, Judge, I think, they're good. You can do those.
I'm sorry. We went back there now. Just have a seat. As soon as he comes in, I'll take care of these, okay?
Yeah.
Did I have this one yet?
No, he's done.
George Ivan Gerganis. 3R715128. Your name, sir.
George, I think you're answer.
You're charged with failure to complete the domestic violence program with 26-week follow-up. Placed you on probation on September 17 of 24. Do you understand that charge?
Yes.
If you plead guilty, if you're found guilty, you could have your probation. Let me see, I could give you 5 days on that. There's only one violation. Do you understand that?
Yes.
And did you sign, read, and understand an advice of rights form here this morning?
Yes, I do.
If you plead guilty, you will be giving up all those rights and there will not be a hearing or a trial. Do you understand? Now, you have the right to a lawyer. I'll be happy to give you one now at public expense if you want one.
No, I'm fine. Thank you, sir.
You waive your right to a lawyer?
Yes, sir.
To the charge that you failed to complete the domestic violence program with 26-week follow-up, how do you plead?
Plead guilty.
Call in Emily, please. Were you ordered to, and did you fail to complete the domestic violence program with 26-week follow-up?
Yes, sir.
Anybody forced you to plead guilty?
No, sir.
I'm gonna accept your plea. I find it to be an accurate plea made voluntarily and understandingly. That plea is accepted. You can have a seat. We'll call her over and we'll take care of this, okay? John Joseph Boland, 25F244666. I'm sorry, 668 A and B.
Mike Baldwin, house comes up with this guy.
Your name, sir?
John Baldwin.
Does he stand mute when formal reading?
On the arraignment, yes, Judge, thank you very much.
And now he's going to plead to no ops and speeding 5 over. They're going to dismiss the suspend, correct?
Yes.
If you do that, possible penalties, sir, are up to 100 fines, 90 days jail, costs are all those. And then 1 point will be added to your traffic record if you're convicted of the speeding, if you plead to that. Do you understand that?
Yes.
The no ops is 0 points. You understand that?
Yes.
Did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you will be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
To the charge, no valid operator's license on person, how do you plead?
Guilty.
To the charge of 5 over, how do you plead to that charge? Responsible or not responsible?
Responsible.
Were you operating a motor vehicle on West Huron River Drive near James and Flat Rock, August 19 of 25?
Yes.
Did you have a valid license on your person? Are you on probation or parole? Does anybody force you to plead guilty?
No,
Plea is accepted, and to the charge of 5 over, how do you plead? Responsible or not responsible?
Responsible.
I'll accept that plea, accept the plea to no ops, dismiss the suspend. Counsel, he's still suspended. Why is he suspended
Yeah.
here?
Thank you, Judge. He's got paperwork in his hand. I quickly reviewed it. Historically, going back, he got a ticket from an officer years ago regarding a medical condition. He was subsequently evaluated by a mental health expert and found that the medical condition did not exist. He was secured his license again, and then fast forward, he probably picked up a ticket, didn't take care of it, and that's where we're here now. But he does have paperwork in his hands regarding his ability to secure his driving privileges.
Anything you would like to say, sir? 155 on the speeding. On the no ops, 100 fines, 80 costs, 75 victims' rights fee, $50. Justice assessment, 305 or 60 days. So you owe the court 460. Can you pay that today?
How much, Sharon?
460.
450? No, I can't pay.
How much can you pay today? Where do you work at?
I'm a social security disability.
All right, you pay $100 now on the speeding. You get a check this month still?
No, the check just came.
You pay the balance on the speeding, which will be $55 by October the 4th. You pay $100 by October the 4th on the no ops. 2. And then 100 per month until paid in full, beginning November the 4th. So you pay $100 today. And then you're going to pay 55 plus 100 on the no ops for 155 on the 4th of October or before. And then you have to pay $100 on November 4th, December 4th. I think you'll have a balance of $5, and then you can pay that if you want January 4th. Okay.
Thank you, Brad.
Best of luck to you. I want to quickly take Mr. Gerganis. George Ivan Gerganis, 23R715-1280, waived his right to a lawyer. He pled guilty. Excuse me. Your name? Name.
George Gerganis.
Still wish to waive your right to a lawyer?
Yes.
What do you think's going on here?
It's not really his fault. The reason I issued this is he's out of time, the 17th. He had got new employment, it conflicted with the classes. PRS has been working with him, but it's kind of on a challenge. He does, as of today, he has 21 of the 26 done. I just think one of his small extension to finish it.
This was taken under 769, Lisa. I'm going to need another date. Anything you want to say in 2 months? Anything you want to say?
No, sir.
Probation's extended for a period of 2 months until November 17 of 25. That results in additional probation fees of 40, pay costs of 50. So your total's $95. I will give you a new review hearing date. You complete the program. We should be able to do this the end of October, Lisa.
November 1st.
November 1st of 25 at 8:30 in the morning.
I'm sorry, Judge. I looked at the calendar wrong. November 4th.
November
9 o'clock.
4th at 8:30 will be your review hearing. Okay?
Yes, sir.
Can you pay the $90 today or not?
Yes, it has to be around 3 o'clock.
Just pay by tomorrow. Pay by tomorrow, September 5th. Okay?
Yes.
Good luck to you.
Thank
Get that all taken care of. Where did Mr. Baldwin go? I want to make sure. What's your name again, sir?
Josh Fleischer.
What happened with that file? Oh, he's still here.
Colin, Ms. Nicholson's here on behalf of the state of Ohio. Ms. Nicholson.
Your Honor, it is my understanding that the defendant will be entering a guilty plea to that of assault, a felony of the 4th degree. The victim was an EMS personnel. count 3 of physical control and count 4 resisting, the state will be dismissing the F5 obstruction.
All right, Mr. Collins, is that accurate?
That's correct statement, Your Honor.
All right, Mr. Ulmer, they're telling me you're going to change your plea to some of the counts of the indictment before we get to your changed plea. I am required to go over some things with you. Okay, sir?
Understood.
How old are you?
35.
How far did you go in school?
I actually dropped out, obtained my GED a couple years after.
So are you able to read and write?
I am.
Are you a citizen of the United States?
I am.
Has anyone promised you how the court would sentence you on these charges?
No.
Has anyone threatened you in any way to get you to plead guilty against your will?
No.
Are you satisfied with the representation you received from Mr. Collins?
Yes.
Are you currently under the influence of any drugs or alcohol?
No.
Do you take medication that interferes with your ability to understand what's going on today?
I do not.
I have in front of me a document. This is called a change of plea. On the second page, on the line mark defendant, there appears a signature. Did you sign this?
It is my signature.
Did you read this and go over it with your attorney before you
did.
signed it?
Yes, sir.
And you believe you understand what it says?
Yes, sir.
This document says you're entering a plea of guilty to 1 count of assault as a felony of the 4th degree. That carries a maximum penalty of 18 months in prison and a maximum fine of $5,000. The prison term is not mandatory. The second count is one of having physical control of a motor vehicle while under the influence as a misdemeanor of the 1st degree. That carries a maximum penalty of 180 days in the Warren County Jail and a $1,000 fine. That also carries with it a potential license suspension of up to 1 year. And on the third count, one of resisting arrest, a misdemeanor of the 2nd degree, that carries a maximum penalty of 90 days in the Warren County Jail and a maximum fine of $750 fine. Do you understand all the maximum penalties?
I do.
In addition to the maximum penalties on the felony charge, you are also subject to a discretionary period of post-release control. What that means is that if you are sent to prison on the felony charge upon your release, the adult parole authority may supervise you for up to 2 years. If you violate those rules of supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time you get sentenced to. Do you understand that?
Yes, sir.
But as I've stated, it's not mandatory that you're sent to prison at all. The court does have discretion to place you into community control, what some refer to as probation. While on community control, you will have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, sir.
Now, you are presumed innocent of these charges. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, you have the right to confront and cross-examine each of the state's witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You also have the right to remain silent. At your trial, you cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you. And I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense. And if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
You could also waive your right to a jury trial, but maintain all the other rights we've discussed. You can try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt or would be required to find you not guilty. Do you understand that?
I do.
Do you believe you understand each of these rights we've discussed?
Yes.
You understand that when you enter plea of guilty, you'll be waiving all these rights. We are not having a trial.
Yes.
This is how you want to proceed.
Yes.
Ms. Nicholson.
Your Honor, if this case would have proceeded to trial, the state would have proven on or about May 3rd, 2025, on State Route 63, Turtle Creek Township, Warren County, Ohio. The sheriff's office and EMS were called out to an unresponsive male. EMTs tried to assist the defendant. He struck EMT Corey Gerdeman 4 times. Additionally, he had an odor of alcohol on his person, bloodshot eyes, slurred speech, and indicators of impairment. He was the operator of that motor vehicle. Additionally, when placed in handcuffs, he resisted that by attempting to pull his hands away.
Mr. Collin, anything on those facts?
Now, with regard to those facts, obviously I told my client we have an opportunity in sentencing to
Mitigate.
mitigate.
Mr. Ulmer, did you hear the statement that she read?
I did.
Do you admit and acknowledge what she said is true?
I've only seen the video one time. I'm a little unclear on the putting my hands behind my back. I felt like at that point I did do that, but yes, 100%.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we went over.
Yes, sir.
What is your plea?
Guilty.
The court will make a finding then that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we discussed. The court will accept your plea of guilty. And based upon the statement of facts and your plea, the court will make a finding of guilty. Now, I'm not going to get into the matter of sentencing today, Mr. Ulmer. Quite frankly, I don't know enough about you to sentence you properly, so I'm going to order a pre-sentence investigation. We'll come back in a few weeks and do sentencing at that time. So if you just stay in contact with Mr. Collin, you do need to go back down to court services and schedule your interview. Ms. Nicholson, is there anything else?
No, Your Honor.
Mr. Collin?
And now I go down the hall to schedule the disposition.
Yeah, Jennifer's out, but I think Ginger will schedule it for you if you ask her. Okay? All right.
And Your Honor, just for the record, the victims were consulted and were in agreement with
All right.
this.
Thank you. Anything else?
The only thing would be in that we do a sentencing memorandum, and I'm thinking it may be helpful for the court to maybe watch the video. Do I just attach that if the court would want to see a little bit about?
That's what you want me to see?
Okay, just attach it.
Sure.
Okay. Thank you.
All right. Thank you all.
Thank you.
Is it Marvin Thompson? Marvin Robert Thompson II, 25M706027. Is he here, Lisa?
And Zoom.
Okay.
I brought him in. It's just taken a minute.
All right. Mr. Thompson, you can unmute, start your video, and tell me your name, please. Okay, now tell me your name. There you go. Your name?
Okay. Marvin Thompson.
All right, wait a minute. We're not getting a very good connection. Where are you?
I'm home right now.
I can't hear you. What'd you say?
I'm home right now.
Should you understand me, son?
You hear me?
I'm home right now.
You're home now? Okay, just stay right there. You're going in and out. You just stay right there. You have a probation violation. Can you hear me?
Yes, I hear you.
You know, charged with alleges you failed to pay your fines and costs as ordered, balance $100. And also that you failed to provide proof of completing 30 hours of community service by July 1 of 25. If you plead guilty, or if you're found guilty, that would be 2 technical violations. You could get 10 days. Do you understand that?
Yeah, I understand, sir. But I got in an accident.
Hang on.
So
hang on.
Okay.
Wait, please. Just this is going to be hard enough. I can tell. You're going in and out. I need you seated somewhere with a light on so I can see your face. And I need there. And now have a seat somewhere where we can get a good connection. There you go. That's much better. All right. Now, just stay right there. Can you hear me?
Yes, I can hear you.
All right. So those are the two charges. You have the right to a hearing. You're presumed innocent. They have to prove that you're guilty by a preponderance of the evidence. You have the right to bring in your own witnesses. You have the right to testify or remain silent. If you remain silent, that silence would not be held against you. Plead guilty, you're giving up all those rights. And there will not be a hearing of any kind. You understand that?
Yes, sir.
All right. Now you have the right to a lawyer. If you want a lawyer, I'll give you a lawyer at public expense. Would you like a lawyer?
I don't know. But I got my reason why I didn't finish.
Here's how it's going to work. When you tell me if you want a lawyer or not, I'm going to give you a lawyer if you want one. If you tell me, Judge, I waive my right to a lawyer, I'm going to ask you how you plead. This isn't going to be a conversation. And then I'm going to ask you if you plead guilty, whether or not you're guilty, and I'll establish that you are guilty if that's how you choose to proceed. If you plead not guilty, I'm going to get the probation officer in here and we're going to have a hearing. Do you understand that?
Well, okay, I don't want no lawyer. And I plead not guilty.
I can't hear you. Listen, I don't want to make you come here from North. Listen, I don't want to make you come here from North Carolina. I don't know what device you're on, but I'm not getting a good feed here. Okay. So just stay. Are you on your phone?
Yeah, I'm on my phone.
Do you want a lawyer?
No, sir.
I'm going to ask you now how you plead. To the charge that you failed to pay your fines and costs as ordered of $100 with a $100 balance, how do you plead?
Not guilty to that because I got a reason why I didn't finish that.
Hang on.
Good reason too.
Hang on. That's part of an explanation. Okay?
Well,
I'll get probation over here. I'm going to enter a not guilty plea for you. We're just going to have a hearing. That's what I'm going to do. Okay? We'll just have a hearing as to whether or not you paid your $100 when you were supposed to. I need Beth in here. And whether or not you completed your community service and provided proof. So stay where you're at. Mute yourself. Try to get yourself in a good location. We'll have a hearing then. Okay?
Okay.
Joshua Edward Schaefer. 215-235-3218.
Again, for the record, your Honor, House Counsel Attorney Mike Baldwin, he certified Baldwin said on behalf of Mr.
Your name, sir?
Josh.
He's going to plead to no ops. They're going to dismiss the suspend. True?
Correct.
Is that what you want to do?
Yes, sir.
If you plead guilty here, the possible penalties are up to 100 fines, 90 days jail, costs are all those. Do you understand that? Did you sign an advice of rights and read and understand the rights?
Yes.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand?
Yes.
All right. You understand everything?
Yes.
To the charge, no valid operator license on your person. How do you plead?
Yep.
On the 24th of March of 21, were you in the city of Flat Rock County of Wheeling operating a motor vehicle on Telegraph near Wheeling at roughly 3:37 p.m.?
Yes.
Do you have a valid license with you on your person?
No, sir.
Are you on probation or parole? Were you on probation on March 24 of 21? Anybody force you to plead guilty or promise you anything to induce you to plead guilty?
Absolutely.
Plea is accepted to no ops. The suspend's dismissed. I'm ready for sentence. Anything you'd like to say? Where's he been?
Yeah, and that's exactly where I was going. So in my notes, Judge, about early.
He lives on West Jefferson in Brownstown.
I'm going to explain. About early 2022, he went into jail county.
I'm sorry, what?
County jail.
When was that though?
Sometime in early 22. He picked up another offense while in the facility, which put him on a discharge of January 25. He walks into.
What year? 23 or 22?
25, January 25, he comes out. So he did 3.
He did 3 years?
There was some, hold on, that's okay. We're recording, so we have to make sure we don't talk over each other. Judge, he did 3 years county time because he had an offense while in the facility.
What was he locked up for 3 years for?
I went in for driving unsuspended and they gave me 6 months, no fines, no costs, no probation, no nothing. And while I was in there, I got into a fight and 2 guards got hurt and I got charged for that.
So he came out in January of 25. He's turned himself in to take.
You got in a fight with corrections officers?
No, sir.
They just got hurt. They were.
Yeah, it was, I got into a fight with another inmate. Officers got hurt. One dislocated their shoulder and then the other one bumped their head on a bed.
So that's where he's been. But Judge, he did walk in.
In August. Why didn't he walk in January? Why didn't you walk in January?
I honestly thought this was taken care of. It's been a long time, and I swear to you, sir, I could have swore it was taken care of. Due jail time, I thought it was due jail time. It was taken care of. Like a concurrent.
How could he have been? What month did you go in what year?
I'm not exactly sure the month, sir.
It was early 22, Judge.
Lives on West Jefferson?
No, I moved to Navy, Michigan.
Do you work?
Yes, sir. Backyard products. I'm a machine operator.
What else? Anything else?
Judge, as we get older, we change. He realized that he had to take care of this. He's here. He's ready to take responsibility. I will note, Judge, I did see a 2025 police report. So I think that he may have another DWLS coming down the pipe.
So you got 6 months on a driving suspended?
They offered me to do serve time on it.
Hang on a second. Let's slow down. Where were you that caused you to get 6 months on a driving suspended?
No.
So on a drive while, was it drive while suspended or drive while revoked?
You actually helped me break that cycle by lifting the suspension I had on my license.
For the insurance, right?
Oh, geez. He's got a GB.
Well, one was pled down to a misdemeanor, Judge.
But the offense date was July 13 of 23. I thought he was in custody in 23.
I think that was the offense while he was in custody is when it happened. So he was a ward of the state when that, or the county when that happened.
Well, he just told me he got 6 months out of Monroe, right?
That was the original charge.
I get it.
And then while I was in there, it was like.
Well, I got an offense date for. Pull him up, please. I don't see him. You got to put in his first name. It's Joshua. Look at number 4 and look at number 4. This was out of Brownstown. You were charged with assault. Can you go down a little more? It was a domestic violence from July of 23.
Okay.
Where were you then? It's out of Brownstown. You couldn't have been in the.
To Wayne County, Brownstown took me to Wayne County. I did.
Listen to what I'm telling. You were out of custody in July of 23. True or false?
True.
I thought you just told me. You guys just told me he's in custody for 3 years.
Yeah, his story's not adding up. 22 to 25. That's what.
This is prior. You said 21. The charge is in 21.
Our
You asked
ticket
where
is-
I, well, you asked where I've been lately. That's where I was at lately.
the ticket was in 21.
Yes,
This ticket was in 21.
yes.
And my inquiry is as to why he didn't show up on this case, like people that tell me that he's been in custody. He was in custody until January of this year. He was in custody for 3 years. This offense out of Brownstown happened in July of 23. If you were in custody for 3 years until January of 25, I promise you, you were in custody in July of 23.
Right.
That was only 18 months before you were released from the Monroe County.
Sir, the ticket was in 2021. After that, I went to jail when I got that ticket. That's what I was trying to explain to you.
What he's saying, what the judge is saying is, where have you been that you didn't take care of the file?
Well, I was in jail, and then now that I got on, I've been working. I'm trying to take care of it now. That's
Judge, he wasn't in jail in 23, obvious.
You weren't.
I was absolutely in jail in 23.
Well,
I went to Brownstown took me to Wayne.
Hang on one second. Lisa, am I missing something? Can you tell me the offense date on that? I see he was arraigned on assault with intent to do great bodily harm in July of 23. Judge Hessen arraigned him
Still on probation.
to the Wayne County Circuit Court, right?
Yes, sir.
When did that offense happen?
And 23, July.
Well, then you couldn't have been in custody in 23. It happened in Brownstown is all I'm saying to you.
Oh, yeah, I don't know that. I was absolutely incarcerated. I went from the jail in Detroit to Monroe.
Judge, there's no valid reason why he didn't.
All right,
So
let's let it go.
you weren't in jail in 20. You weren't in jail from 22 to 20 because you were out in 23.
That is absolutely incorrect. I've been incarcerated.
Don't start pointing. Hang on. Don't start pointing your.
How can you tell me I'm lying right
Hang on a second.
Sorry, I apologize.
Don't start pointing your finger at me. I'm trying to get.
No, I was putting it in the page. Sorry.
We're just have a casual discussion and then hold your position.
Can you
seeing something that doesn't add up? That's all.
Okay.
Can you tell me what the offense date was on that GB? It's a 23 case. You couldn't have been in custody. It was a 23 case out of Brownstown.
I swear to you, sir. I'll give you my probation officer's number. You can call it right now, sir. I was absolutely incarcerated.
Unless that was one of those that happened 2 years earlier. Can you make heads or tails out of that, Lisa?
The way my probation.
Hang on one second.
Hold on, sir.
Are you talking about the felony charge?
Yeah, 23B715135. I'm trying to
Yeah.
find the.
It's showing an offense date of July 13th of 23.
Right.
So
if there was an offense date of July 13 of 23 out of Brownstown, you couldn't have been in the Monroe County Jail.
I went to Brownstown, and then from Brownstown, I went to Monroe because I had a warrant out of Monroe for the driving unsuspended. They offered me 6 months,
Okay.
and within that 6 months, I got in trouble. They got into a fight and hurt the officers. Well, the officers got hurt. I did not hurt them.
I believe you, but you
is it possible that
you acknowledge that you weren't in custody at the time of this case out of Brownstown that allegedly happened on July 13 of 23, for which you're on probation now? That's all I'm asking.
Yeah.
Okay.
Yeah.
Well, you guys were telling me that you were in custody for 3 years until January of 25. Now, I don't have to be that good at math. If you were in custody for 3 years and got out in January 25, that means sometime around early 22, you were in custody from there until January 25. That's all I'm saying. I'm not arguing with you.
right? Is it possible it was 23 to 20?
I've heard enough. Let's move on. Let's move on.
Got it.
Anything else?
No, Judge.
Anything else?
Fines and costs. It's an old case. I explained to him this needs to be cleaned up.
If he was in custody for 3 years, I was going to give him credit for time served. That's why I was belaboring it. Anything else?
No, sir.
100 fines, 120 costs, 75 victims' rights, $50 justice assessment, 40 in attorney fees, 385 or 90 days. Can you pay that today?
I have half right now, and my wife can go get a loan with my in-law.
Yeah, I don't need you to get a loan. You pay 190 now, and I'm just going to give you until September 26th to pay this. Can you do that?
Yes, sir.
If you don't have the money, you can either call the court, go on Zoom with me on or before the due date, or you can come in here and talk to me on it before the due date, okay?
And we apologize for the.
It's all right. Forget it. Forget it. Good luck. Marvin Robert Harrison Thompson, Marvin Robert Thompson, the second, 25M 706-027. All right, Ms. Wild, your name? Can you hear me, Mr. Thompson? You have to unmute yourself, sir. There you go. Now your name again?
Marvin Thompson.
All right, so I've got the probation officer in here. I'm going to swear her in. She's going to testify, and then you can ask your questions. And if you don't want to ask her questions and want to testify, I'm going to swear you in. You don't have to testify. You have the right to remain silent. Do you understand everything I've said?
Yes, sir.
All right. Ms. Wilds, raise your right hand. Solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God. All right, go ahead.
Show cause arraignment dated August 25th, 2025. Two allegations that the defendant failed to pay fines and costs as ordered. His balance, which I did check just prior to entering the courtroom, is still at $100. The court ordered Mr. Thompson to pay $140 at the time of sentencing, which was April 22 of 25. And then the balance at the rate of $100 per week beginning May 2nd of 2025. Just based on that calendar of payments, that balance should be zero prior to today.
All right. What about the community service?
In regards to community service, again, the court ordered on April 22 for Mr. Thompson to complete 30 hours of community service by July 1 of 25. As of his visit, which was scheduled for July 7th, 2025, 0 hours of community service have been provided.
Do you have any questions of her, sir?
Like I said, I got a reason why all that is not done.
Slow down.
Yeah.
Hang on. There's a process here, and the first process is, do you have any questions for her?
No.
Do you wish to testify or do you wish to remain silent? If you wish to testify, I'm going to ask you to raise your right hand. I'm going to swear you to an oath.
Well, I testify.
Raise your right hand then. You solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God.
Yes, sir.
Okay, go ahead. Tell me what you have to say.
Okay. First of all, I was paying the money. I got bills. I got kids. I got 5 kids. I'm paying helping my sister's house. And other than that, I've been in a truck car wreck. That's why it's not paid today. Look at my arm. I mean, y'all don't know that, but
Slow down. Slow down. We're not picking you up. We're not picking you up now. Okay. You got in a car wreck. You showed your run. You got kids. All right. What about the community service?
I started the community service, but I didn't finish. Only way I didn't finish and paying the fine because my arm. I went after I got locked up from y'all. I went back on the road, and about 2 months ago, I got in a truck accident in Idaho. So I almost broke my arm. I've been home.
That didn't happen until July, though. You were supposed to have it all done by July 1, weren't you?
Yeah, I know.
So you didn't do it timely, right? You agree with that? I mean, you want to quarrel about this.
I didn't do it in time. Yeah, you're right. I didn't do it in time.
All right.
I was on the road and I was paying for the truck payment. I had a truck payment. I wasn't like no company driver. I was working on the road at that time.
Just relax.
Okay.
I told you when I sentenced you, if you didn't have the money to call the court, we'd go on Zoom. I'm going to find you guilty as to failure to pay fines and costs because you didn't pay them as you were supposed to. And I'm going to find you guilty of failure to complete your community service. Now, we're going to resolve it. Sir?
Go ahead.
I don't know what you want me to do. You didn't have your accident. I gave you all kinds of time. I gave you 11 or 12 weeks.
That time I was working on the road, and I like it's hard for me to come home. When you were working on the road as a truck driver, they give you like 4 days home every month or something like that. And then I was a lease driver.
Slow down.
I was a lease driver, so that meant I had to make the truck payment.
Slow down.
Okay.
I ordered it April 22nd. You still don't have any done, and it's September. Listen to me.
Go ahead.
I'll give you some more time. I don't have a problem with it. But you gotta get on this, okay?
Yeah, I got on it. I mean, I don't got on it. I can give you the people number and all that. I done started my community service. I just ain't been back since I got in the grid. I almost broke my arm. My whole semi-truck flipped over.
Sir, I'm gonna give you extra time, but the fact remains you didn't do it when you were supposed to. You got your accident after the due date, and we didn't get anything. I'm not arguing with you, but you seem combative, and it's nobody's fault but your own.
Yeah, it's my fault. It's my fault.
How much time you need to do your community service?
I should have everything done before this month out.
Before this month is over?
Yeah.
I'll tell you what. You pay additional costs of $60. I'm keeping you on probation. Community service due by October 16th. So I'm giving you better than that. I'm not going to order any other community service. You pay your costs of $60 by October 16th, and you get your 30 hours of community service done by October 16th. Okay? Fair enough?
Okay. Yes, sir.
All right. Nobody's here to argue with you. Good luck. Thank you.
Thank you.
Randy Lee Shoemaker. 24B724247.
Ready, Your Honor.
You're all set, Mr. Thompson.
Judge, today, Attorney Mike Baldwin, House Counsel for Mr. Shoemaker. So I think you just
Need on this one.
Lady Lee Shoemaker. Judge, today's the date time set for a VOC. There is an advice of rights. My client's going to plead guilty with explanation. We're going to ask that the judge adjourn the sentencing past Tuesday.
Well, let's talk about that in a second if we can, okay? Look, if you plead guilty here, this would be a technical violation. You could get 5 days. Do you understand that?
Yes, sir.
Did you sign the advice of rights and read and understand the rights?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing. Do you understand?
Yes, Your Honor.
You understand all these rights, correct?
Yes, Your Honor.
To the charge, you failed to provide proof of completing 120 hours of community service by August 1. How do you plead?
Guilty.
Did you fail to provide proof of completing 120 hours by August 1?
Yes, Your Honor.
Anybody force you to plead guilty?
No, Your Honor.
Going to accept your guilty plea. Counsel, you know what? This was a terrible accident.
It was, and I see it was dropped down, so there was mitigating factors.
There was no mitigating factor.
Well, yeah, I'm sure it was a fellow.
There was no mitigating factor.
Okay.
Well, I mean, he was driving in the left lane of southbound Dix, crossed the center turn lane, the left turn or the left lane of northbound Dix, the right lane of northbound Dix, and the curb lane. Crossed across 4 or 5 lanes and killed somebody. Why did you not take this seriously enough to get this done?
He has 27 hours left. It's scheduled for this Tuesday.
Supposed to be done.
And then he'll have it done.
I'm accepting your plea. Nobody's forced you to plead, right?
No.
Your name. I'm going to tell you how I feel about this, Mr. Shoemaker. I'm not surprised you're here. I'm not surprised you're here. I'm not at all surprised you're here. You know why I'm not surprised you're here? Because I remember how you reacted when I gave you 75 days, which, if anything, was a gift. You killed somebody. You drove across 4 lanes. You tried to tell me, and your lawyer tried to tell me you were looking down or trying to change the radio. Right? You know how good that is that I can remember that when I sentenced you back on April the 8th? That's how telling that was to me. You crossed 4 lanes. You didn't just go across 1 lane divider. So I want to know why you're here, why you didn't get this done. I'm dead serious about this.
You're not going to like it. But you already probably figured that out by now, Judge.
Well, I know I'm not going to like it. But I need to know why he didn't take me seriously. He's not taking this seriously. I remember him almost kicking and screaming, I'm going to lose everything. What about the guy who lost his life?
He was in jail until June 9th.
For what?
For the moving violation, cost and theft.
Yeah, I know, but what's that have to do with anything? I gave you until August 1 to complete it.
I understand that, Your Honor, and I was working and trying to maintain doing my community service and doing work at the same time. I have 3 children.
It's now September 4th.
I understand that. I got 27 months left.
He's done 93 hours. He's done 93 hours. He has 27 left. They're scheduled to be done next Tuesday.
Your name?
Alex,
How can you do 27 hours next Tuesday? You mean all of them are scheduled to be done by next Tuesday?
Yes, Your Honor.
And he did bring in proof today of the 93 hours that he has done.
All right. I'm accepting your plea. I'm going to listen to whatever else anybody has to say. We'll go from there.
Judge, thank you for accepting the plea. We're asking that you adjourn the sentencing past Tuesday to afford him an opportunity to complete the community service as instructed by the court.
Anything you want to say, sir?
I would advise you not to say.
Well, you're fine. I mean, hey,
Okay, you say, but you want to the judge. I would say, Judge, he's getting it done. He's got substantial compliance. We understand the situation.
I'm going to assess additional costs of $75. You're to complete 10 more hours of community service. Defendant to provide proof of completing 130 hours of community service no later than October the 7th. I'll give you a few extra days. That's it. You pay the 75 now, you have 130 hours community service completed by October the 7th. Good luck.
Thank you very much.
People against Zarnick, Elijah Michael Zarnick, 35T644864. Counsel, I'm going to take Ferguson after this.
Yes.
And then Fuller after this, and then Silver after this, if those are yours, and then Wokosh. Good morning, Mr. Nelson. Your name?
No, Your Honor, may I start?
Yes, please.
Sir, your name, please?
Oh, sorry.
So this could be a plea